I will call this meeting to order. This is going to be our annual training session for our new board members, and Tom Slayton will be conducting the training. It is available to Zoom them on Zoom to our community. We don't have the chat function because if this is just a training, there's no interaction or chat from the residents who are joining us. So Patrick is letting everyone in the room and we will get started.
Can I just add one comment?
Yes.
It's for all board members, not new board members.
Yes.
By law, every board member
Sorry.
has to sign every year that you went through this course. And
Yes. To clarify, yes, I think we've all done.
every year you have to sign on the dotted line. Right? Am I right, Tom?
If you had an uninterrupted term of service, you actually don't have to take the class or fill out the form.
Oh,
that's
really?
That's a recent change in the law, but I welcome you anyway. So.
All right.
I think at this point, though, we're all here and we're all going to participate. Just for the group, our lunch is going to be delivered at some point during this meeting. So, but we will turn it over to Tom. I think you can hear us all, Tom?
Yes, I can. Thank you.
Good to go. Thank you very much. The floor is yours.
All right. I need to be able to share my screen. It still shows that it's disabled.
Patrick's working on that.
Okay. Thank you. Thank you. All right. All right. Well, good morning, everybody. This is a board certification class. It's one of the requirements for especially new board members, but it doesn't hurt to brush up if you're a continuing board member. It's something that the state requires, and I'll get a little bit into it in a moment. But I always like to lead off with a little bit about why you're serving on the board. And one of the main benefits of having a community association as opposed to not, and maybe a little bit about the purposes of it. And I think sometimes it helps to remember that when you don't live in a community association, or even if you do, but there's not a lot of active enforcement of covenants and restrictions, collection of assessments, and active participation in the community, you can sometimes find yourself living next to, across the street from, or down the road from, unfortunately, a property that looks like this. So when you go to meetings, you're thinking about what you're going to be doing. You get challenged by some homeowners who say, hey, how come you're being so strict? It's important to remember that one of the main reasons that a lot of homeowners move into deed restricted communities like CROA and other communities is because they want to avoid a problem with a house like this, or to preserve their property values, or basically just to enjoy where they live. If you look in the upper left-hand corner, that's pretty much a house that I used to live next to back in 2006, 2007, when I was living up in Winter Garden. Unfortunately, a homeowner, because of financial reasons, basically lost their home, let the property go. And as you can imagine, if I wanted to sell my house, I would not have been able to, or certainly at a deep discount. And then I got questions all the time about, well, how come you have to live next to that house? Can't somebody do something about it? And the answer is, of course, yes. So when we think about some of the powers and responsibilities that I'm going to go through, just think back to the fact that, this is a worst case scenario. It's something that we definitely try to avoid. But it's important to remember that you all are doing this in part to protect the neighbors and to protect the value of this property and make it come into compliance, meet the community-wide standard that we all have. I have Patrick Dumais entering the waiting room. I'm going to go ahead and admit Patrick. All right. All right, so like you have board meeting agendas, I have an agenda for the class. The agenda is going to include general information, meetings, official records, which we talked about a little bit already, budgets and reserves, financial reporting, contracts and bids, that's going to become important this year, collections and assessments, and suspensions and fines. During the course of the presentation, there's going to be some slides regarding condominiums. I'm going to kind of skip through some of that to save you all some time, and that way we may have a little bit of time at the end of it in case you want to ask any additional questions. If you do have a question during the class and you want to ask me a question, just shout it out. I want it to be interactive and make sure that I'm answering anything that you have about the particular topic that we're on. All right, let's start for board member general information. It applies to condos as well, but I'm going to focus on CROA. As I mentioned before, as you probably heard, there is a requirement for new board members to either sign a certificate acknowledging that they've read all the governing documents, you understand them, and that you will enforce them to the best of your ability. And that has to be done within 90 days becoming a board member. or you can take this member training program. We actually have certificates available for you all. And then now that we know who the new board members are, we'll go ahead and issue certificates with your name on it and send them over to management so that they can share those with you as well and keep them as part of the records. If you had a board member who did not take this course or fill out the form, they could actually be temporarily suspended until they did the requirement, at which point they're back on the board. Later on, I'll talk about a little bit about what happens if you're permanently removed from the board as opposed to a temporary suspension. This is just temporary. If it wasn't complied with, as soon as the compliance occurs, the board member who was temporarily suspended gets back on the board. All right. The question I think David O'Brien brought up, do you have to continue to do this? The answer is no, but again, welcome and thank you for listening to me for another couple of hours. All right, let's talk about your general powers. CROA is, like every other homeowners association, a corporation. And as a corporation, it has a board of directors. And as a board of directors, you have the power and authority to do a number of things as leaders of the association, tasked with certain responsibilities, including entering into contracts, filing lawsuits like construction defect lawsuits, making decisions if the association is sued for the betterment on behalf of the association. You also make decisions regarding common areas. You can address disputes with a developer. You can challenge property taxes, and you can pretty much do anything that your governing documents vest with the board. So there's certain things you may not be able to do, like amending the documents requires a vote of the membership, but most decisions are going to fall to the board of directors as elected representatives for the rest of the community. In addition to your general powers, you have some emergency powers, and these have developed over time. And I'll talk briefly about some proposed changes in the law that will address the current pandemic. So most of these state emergency powers probably fall within the what happens if you have a hurricane situation, where you can conduct a meeting with practical notice. Normally, you're supposed to post notice in a conspicuous place, but if the property area was destroyed, then you can do the best you can. If people escape the area in order to avoid a hurricane, for example, you can appoint non-director assistant officers to fill in. You can actually levy special assessments without a vote and borrow and pledge assets to fund repairs, just as the board. And these last two things kind of underscore what the state is looking towards with respect to the purpose of any community association, including CROA, which is to protect and preserve property. So that's why even if you had a requirement that you had to get a membership vote to do either of one of these things, it's so important to the state that the board have the power to actually undertake these actions without a membership vote, that they give you these powers in the event of an emergency. So if you had debris after a hurricane and it was blocking the pathways through, the roads through the community, that the state wants you to be able to address that. If you had damage to a clubhouse, they want you to be able to repair that. If you had damage to your stormwater drainage system, it was overwhelmed and you need to take emergency action, the state wants you to have these specific powers, even if they weren't granted in your governing documents. And again, I would underline, it's because the state wants the associations to be able to protect and preserve the community. A miscellaneous board power that we every once in a while talk about is you can have an owner directory with an owner's name, mailing address, and phone number, unless a member asks you not to include the phone number. You can also include additional information as volunteers. Some homeowners like to share their Facebook account number, their dog's name, their kids' names, and things like that. That's all voluntary. But it kind of went back and forth for a few years on even having a membership directory. And the state said, you know what, it does create a sense of community. If you want to try it, you're welcome to do so, but you're certainly not obligated to do it. An obligation that we need to make sure that we always follow, and I check every year, and I know that you do have this, is you're required to have what's called a fidelity bond and insurance for those people that are handling association money. And so that's going to include anybody who can sign a check, as well as specifically the president, the secretary, and the treasurer. Some people think, well, how important is it to have this type of protection? I will tell you that about once a year, every year, I have a client or a management company of a client who reports that somebody took some money from their association. And so it's imperative that you have this insurance or a fidelity bond. It's a common expense of the association. The membership actually has the power to waive this requirement, but since it's only a few $100s, I would not obviously encourage doing that. It's a best practice to have this in place, and CROA does. Although I talked a little bit about what you can do, it's important to remember that there are certain things that you cannot do. And the most important or obvious is that you cannot accept a benefit from a vendor, except that you can accept $25 or less, which means that we can go to McDonald's comfortably, but we're not going to be going to a Fleming's House steak dinner. The purpose of this restriction is basically to avoid a situation where, and this happens every once in a while, unfortunately, a vendor like a landscaping vendor might be up for a contract consideration, and they offer to do free maintenance or lawn service for a board member in exchange for the board member's vote. That's clearly a no-no. It doesn't happen very often, although I do hear a few stories about it. But basically, when you're looking at, what you get out of this, besides the obvious $0 salary and benefits to the community, is very limited. And so if you ever find yourself in a situation where a vendor is making these types of offers, just let us all know, because we want to go ahead and avoid them. They're obviously doing some sort of business that we wouldn't want to be involved with. So essentially, your service is for free. You can receive $25 or less for just general benefits. And if you're at a trade fair educational program and food is provided or things are raffled off, that's also an exception to it. So if you go to the CAI trade show every year, you're going to see some really nice items that are raffled off. You're actually allowed to accept those. We have a specific couple of slides for condominiums, so I'm going to skip through them. Well, that applies to both, but let's skip through those as well. All right, board member general information for homeowners associations. One of the things that you are limited in doing is engaging in litigation involving amounts in excess of $100,000 unless you obtain the approval of majority of a quorum of the association's voting interest. And we actually did that recently for some of the service areas. Those members that are ultimately responsible for paying for the cost of litigation voted to approve and move forward with the litigation regarding some roofing issues. So it's very rare that CROA would have this. It's typically involving large amounts, usually regarding things like construction defects or construction issues. But if it does come up, then the state does require CROA to go ahead and have a vote of the membership. The reason being that if we're going to be seeking recovery of a large sum of money, it's important for the membership to be aware of it and have some say in it, that it doesn't just all fall on the board. There's actually discussion, at least a little bit of discussion, about increasing this number, but I haven't seen that yet. And to kind of jump back for a second, because I promised this, on the special emergency powers provision that I brought up before, there are some proposed changes to address the current pandemic, so that if there's a repeat of it, that some of the special emergency powers that generally allow us to do things for the pandemic will be specifically incorporated into the statute. Right now, the state recognizes that the emergency powers that we're using to deal with pandemic issues are fine, but a number of us thought, well, let's just go ahead and add it in specifically, so there's no question about that. So we expect that by July, when I say we, the legislative board that I'm on, we expect to have some additional wording in the emergency powers statute by July 1st that clarifies that, yes, indeed, it's always included pandemics. And here's some specific things that you can also do to address that, including things like electronic meetings that we've been doing. All right, board eligibility. There are some limitations on board eligibility. Right now, if you're a member of CROA, you can serve on the board. We used to also allow spouses, even if they weren't named on the deed, to serve on the board. We tightened it up a little bit. And then the state has imposed some additional restrictions. So for example, if a member of the board is delinquent in any payment of any fee, fine, or other monetary obligation for more than 90 days, they're no longer eligible to serve on the board. And so this sometimes happens. I run across this with some associations where a board member has fallen behind on something. They're more than 90 days delinquent. And unlike the temporary suspension that I talked about before, where you're temporarily suspended, but as soon as you comply, you can get back on the board. In this example, this is an automatic suspension, and it's not temporary. It's permanent unless the board turns around and reappoints the board member after they've cured the delinquency, or they're reelected to the board after they've cured their delinquency. In addition, anybody who's been convicted of a felony and has not had their civil rights restored for at least 5 years is not eligible. And if a director or officer has been charged in a criminal complaint with felony theft from the association, they're automatically removed and they can't get back on the board until they're either found not guilty or the charges are dropped, or they've been convicted of a felony and they have to wait the 5 years to clear their name or have their civil rights restored. So this is not so much about being convicted, but having an actual criminal accusation. And it's not just that somebody stood in the back of the room and said, hey, I think you stole money. It's got to be an actually formal criminal complaint. It would be in the circuit court for Osceola County where you'd be charged. And once that happens, once that formal complaint has been filed, that's the only time that this would actually be triggered. So it's very unusual that this happens. But again, as I said, about once a year, I have somebody that's been accused of theft. And so about once a year, I see a criminal complaint. The member is off the board if they haven't already run. All right, board and membership meetings. This applies to condominiums and homeowners associations. I'm going to talk about generally, but you have some specific differences that I'll touch on if it applies. All right, so generally, board meetings are open to unit owners or homeowners. There are two exceptions to this. Meetings between the board or a committee and the association's attorney is one clear exception. Another exception is meetings held for the purpose of discussing personnel matters. Those are also not open. So on the first one, if you're asking if you want me to be a part of a meeting, we're going to be talking about really any legal issue. The statute's a little narrower, but generally there's a second statute. When I say a statute, I mean Chapter 720 Florida statutes. Talks about threatened or pending legal issues. That's covered by the privilege, or anything else that's intended to be covered by the privilege. That's closed, and the reason is to allow an open and honest discussion between me and you all as the board members about any legal matter. If it's open, then the people that we might be talking about, whether it's a contractor or a member of an association that's behind on their assessments, they'd be privy to it. And so that's one of the reasons why the state allows us to close it. And another reason is for threatened litigation. Hey, we have an issue, or we're considering litigation. We're considering filing a lawsuit, but we haven't decided yet. You want to hear the pros and the cons. And if I talk about the cons in front of the public, then it can all be used against the association and weaken the case. Personnel matters, if you're making personnel decisions, that's also able to be closed. And then kind of related to this, we're going to be coming up with the competitive bidding process for management. And, there may be some meetings where we need to close them in order to protect the privacy, I shouldn't say the privacy, but the nature of the closed bidding process, so that information is not shared from us to different management companies, so that one has an advantage over another one. So that's intended to be protected as well. It may arguably be related to personnel matters, but it's certainly part of the intended closed bidding process that we're going to be following for the rest of the year for management. All right, for board meetings, as you know, unit owners or homeowners have the right to participate in meetings with reference to all designated agenda items. So if you have 5 items, then homeowners are allowed to participate and make comments about those agenda items to let you know what they think about them. You can adopt reasonable rules governing the frequency, which means the number of times somebody can speak about items, the duration, the minimum is at least 3 minutes, and the manner of participation. Do you have a sign-in sheet so you can call people up, or do you have them submit questions? Owners are allowed to record board meetings and membership meetings subject to reasonable rules. That's audio recording and that's video recording. Usually the reasonable rules just say don't set something up that's blocking everybody else's view or hearing, or is so loud that you can't hear or use it. I get a lot of questions about, well, if somebody does record your private meeting, because it's supposed to be private, does that mean that they can post it on YouTube? And the answer is yes, they can. I'm on a few YouTube videos. I'm sure you guys are too. I know you guys record your meetings and then you rebroadcast them. Some associations don't do that, and then they see themselves on YouTube and they ask the question, well, that content was edited, it doesn't look appropriate. There's a constitutional amendment called the First Amendment, and they're pretty much allowed to do what they want to with their recording. They can make commentary or voiceover or things like that. So there's really not much that we can do about that, which is fine, because I think it's intended that, it's the First Amendment protection that they're entitled to exercise. Petition agenda items. So your documents are slightly different, but in the state statute standard, it's a 20% of the total voting interest petition to address an agenda item, then they're allowed
I think
to. Did you lose me?
you're back now, I think.
Oh, okay. Did you lose me before the petition agenda item?
Yes, we did.
Oh, okay, all right. So I was just saying that, well, let me back up. So,
We saw that. Yeah, we saw the,
all right.
that we saw the YouTube, and then the next page is where we lost you.
Okay, so we're on petitioned agenda items. So as you know, under the CROA charter, the membership can petition to ask the board to address an agenda item that maybe you had not done. I give an example of a pool. If the community wanted another pool, then they can submit a petition asking the board to take it up at their next board meeting. If you get a petition like this, then you're required to have the meeting within 60 days after receipt of the petition, and you have to give a special notice about the meeting, and that has to be 14 days advance written notice to the membership, which has to be mailed or delivered or emailed for those owners that consent to email notice. And so that's a requirement to address and bring up the petition agenda item. When you talk about the item, you're not actually required to take any other action. So you may think it's not really a good idea. We're going to vote no on it. It's maybe a good idea and we want to table it so we can do some more research. Or you might decide that it's a great idea and why didn't you think about it before? In which case you can take action, positive action on the petition agenda item. But the bottom line is, other than discussing it, there are no other requirements. You're only required to discuss it, and then you can make your decision, or basically table it if you're not prepared to make a decision. Notice of board meetings. For condos, you have to include an agenda. For HOAs, including CROA, you do not. However, I'll warn you that there is a move in the state legislature to require posting of agendas effective July 1st. We'll see if that law passes. It may, in which case this might be revised effective July 1st. But for right now, for just homeowners associations, including CROA, you're only required to post a notice in a conspicuous place, and it should be posted at least 48 continuous hours before the meeting, unless you have an emergency meeting. There are other additional notice requirements. Examples include the annual meeting, non-emergency special assessment meetings, budget meetings where you have to include in the notice that you're going to be meeting about a budget, and amendments to the rules and regulations. All of these, except for your regular budget meeting, require 14 days advance written notice. If you're a condo, you would also have to give the 14 days advance written notice of your budget meeting along with an agenda.
Sorry.
Okay. So for these, the annual meeting, the non-emergency special assessment meeting, and amendments, you have to actually submit 14 days advance written notice by mail, delivery, or electronic notice before actually having the meeting and discussing the issue. So for example, if you're going to change your architectural guidelines, that requires a 14-day notice because that's an amendment regarding rules related to the homes. If you're going to make changes to rules regarding just the common areas, you do not have to have a 14-day written notice. You can do those changes if they're exclusively to the common areas. Like, for example, you want to change the hours for the pool. That's just your 48-hour regular notice, and no special notice is required. For those people that do want to receive notice by email, they need to provide you with a written consent so that you know you can send them email notices in lieu of, meaning instead of, a written notice. If homeowners are just fine receiving email notices, that's great. Sometimes you have email blast out to the community. But for purposes of receiving an email instead of the written annual meeting notice or any other required mailed notice, you want to make sure that they've consented in writing to receiving the electronic email. And I see that more and more homeowners are actually going to this. It's easier for them. But if they haven't consented to it in writing, then you're required to send out the regular mail notice, which you do. I think you used to do broadcast TV notices. I don't think you do that anymore. Am I correct? Okay. Proxies. So when homeowners are participating in meetings, they can show up in person. Or if they want to participate in a membership meeting, they can also participate to some degree by a general limited proxy. Proxies are basically turned in order to generate a quorum and or to vote on certain specific items, like we had the charter. So if somebody wanted to vote on the charter, they could submit a ballot or a proxy in order to cast their vote. Any proxy is effective only for the specific meeting for which it's given, and any lawfully adjourned meeting. However, if you adjourn and reconvene a meeting, that proxy is only good for 90 days. That's per state law. Every proxy is revocable. You'll notice when you see proxies that they're dated. If you see a later dated proxy, that revokes the earlier dated proxy, or a homeowner can simply submit something in writing with a date on it saying, I hereby revoke my, let's say, January 1st proxy, in which case it's treated as revoked and will not be counted. Proxies cannot be used in the election of condominium board members, although they can be used for the election of homeowners association board members, if you wish to use those. As you know, you keep minutes of meetings. You're required to keep minutes of all board member meetings as well as membership meetings. They can be kept in electronic format as long as they're readily able to be printed out, or you can keep them in written form and provided to a homeowner as upon request. Within your meeting minutes, you're supposed to record a number of things: when you get started, when you get finished, what your motions are, including who moved, who seconded, who voted for and against. And sometimes you get abstentions. And that's the one thing that sometimes trips people up. Not you guys, because you're familiar with the abstention rule. But if somebody does abstain from voting in a board meeting on a particular matter, their abstention must be recorded in the minutes. Every once in a while, not that you all have, but some other associations run across this, somebody just doesn't vote. They don't say anything for or against. In which case the state says, well, then you're presumed to have voted in favor of what the majority said. So if it's a majority saying no to a contract and you don't say anything, then you're presumed to have agreed with the majority on no on the contract. All right, board and member meetings, condominium associations. I'm going to skip through this. All right, homeowners associations. So back to you all. Voting at meetings and a quorum. So first of all, there's a special provision that says if you didn't post your notices, you could also mail notice every time you wanted to do it. And that would have to be mailed at least 7 days in advance of the board meeting. You all don't do that. That's time consuming and expensive, and it's not necessary. All right, official records, condominiums and homeowners associations. Contents of your official records. So the state lists what your official records can constitute. And it's important to understand your official records are just generally the records that the association keeps in the operation of its business. It includes plans, specifications, permits, and warranties. Your bylaw.
Again.
Oh, sorry. Let me know if I'm back.
You're back.
Okay, thank you. All right. So official records. Can you hear me now?
No, we are coming in and out, Tom.
Oh, okay.
Is it us or is it him? Can you hear us?
I can hear you fine. Yeah, I've never lost
Okay.
you.
Okay,
Yeah.
there you go. I think you're back.
Okay, all right, sorry about that. So official records, the list here comes from chapter 720, and there's an identical list in chapter 718, which is the Condo Act. And it basically tells the association to keep all records that are related to its operation. And that's going to include plans, specification, permits, and warranties. Of course, your bylaws, your articles of incorporation, your declaration, or as you call it, the charter, your current rules and regulations, including your design guidelines, the meetings of all of your your minutes of all your meetings, including your board and membership meetings, a current roster of all of your members, all of your insurance policies, any contracts to which the association is a party, it's the current copies, bids received by the association for work to be performed, which have to be kept for at least 1 year. So even if you don't hire a contractor, you still keep their bid for at least a year. Your financial and accounting records. There's some more details in your HOA manual that I provided. A copy of the disclosure summary for HOAs. That's where somebody's looking to buy property in CROA, and they're notified that there is an association. You're liable to pay assessments. Is there or is there not a special assessment? Do you have any powers to say or disapprove prospective buyers or renters? And then finally, catch-all. This is where there's a little bit of gray area, as I say. There's a lot of questions about all other written records of the association which are related to the operation of the association. And just a general rule is if the record you've kept is related to CROA's business, then if it's a written record, you keep it and you make it available for inspection and copying. And everything except for the bids have to be kept for 7 years. Homeowners can inspect and copy most of the association's records, with a few exceptions, which I'll talk about, if they bring their own phone or portable electronic device, and then they can record or take pictures of it at no charge. If they ask for copies, then the association can charge, and I'll talk about that. All right. You have the power, if you want to adopt rules regarding inspection and copying of records, including the frequency, which basically means the number of times that somebody can ask. You can limit it to as few as 1 request a month. A lot of associations don't do that, but some do, because you don't want to have records inspection and copying request overwhelm management, so that they're spending a lot of time and effort on that and not on other things. So you can reduce it to as few as 1 time a month, which should be sufficient, because homeowners can ask for, as I said, almost anything, with some exceptions. The amount of time, you can limit it to 1 8-hour inspection period. Location, you can designate where you're going to have the inspection. The notice requirements to you and from you, the records to be inspected, the state says what you can and can't inspect, and the manner of inspection. Is it going to be in a room with somebody supervising? Is it going to be on a computer? Or is it just going to be, please go online and here's your password if you don't already have one, and you can look at pretty much everything you ask for. You must maintain copies of your recorded governing documents, which includes your charter, your articles, your bylaws, your rules and regulations, and your design guidelines, and basically make those available upon request to any homeowner that wants them. And effective for condominiums, renters now have the right to inspect the governing documents as well. Except for these specific governing documents, anything else that somebody wants, if you have to make a copy of it, they ask you to basically make a copy of it. You can charge 25 cents per page if it's going to be made on the association's copy machine. Or if you don't have it, which you do, you can send it out to Kinko's or some other company and charge the actual cost of making the copies for them, and then pass that cost back on to the homeowner. If you have to use a management team administrative person, you can also charge for an hourly rate for the employee to actually do the work for the copy, but not gathering the information. Sometimes I've seen associations make the mistake of charging to actually go and get something from storage. We don't charge for that. We only charge for the actual copying process. Access to records. The records have to be available within 45 miles of the community. You all have it at town hall, so that's not an issue. Or you can make it available electronically if you choose to. If a member is actually denied access to the association's official records, they're entitled to a minimum of $50 per day for each day that they're denied. And the $50 a day starts on the 11th business day after they submitted a request. So if I request something on a Monday, we're not going to count the Monday. We're going to count full business days starting Tuesday, Wednesday, Thursday, Friday, skip the weekend, go to the next week. And then if the association has not made the records available for inspection and copying, it could be charged up to $50 per day, per calendar day, after the starting of the 11th day. As I mentioned before, there are certain records that are not available for inspection and copying by the members, and there's obvious reasons for this. Number one, personal records for management company employees and association employees. There are privacy laws that apply, employment privacy laws that apply to these records, and so the state recognizes them and says, no, these are not available for inspection and copying. Just like we have closed meetings with the attorneys in order to discuss litigation matters, I might, for example, produce an opinion letter or other litigation-related document. Those are privileged and are not available for inspection and copying. There may be some later exemptions or exceptions for this after the litigation is concluded, but for the most part, they're also protected. Information related to the approval of the lease, sale, or other transfer of a parcel. So, for example, if you got certain financial information, you would not have to share that with a homeowner. I'm sorry, with the rest of the homeowners. Medical records. Sometimes homeowners have disabilities. They make requests for what's called a reasonable accommodation. They ask for a ramp in the front of their home, which would otherwise not normally be approvable. But they have a disability. They provide a medical record supporting that. We do not share that medical record with the rest of the membership. Electronic security measures, that's your software passwords. You're clearly not required to share this. Even though I had a lawsuit in Lake County where somebody actually sued to try to get this, it was dismissed as ridiculous. And obviously based upon the plain meaning of the statute, you don't get that. Association software and operating systems. So nobody gets Windows 10 for free. That's software piracy. So obviously that's excluded as well. Even though a portion of every homeowner's assessment went to pay for it, that's protected and owned by CROA and its management company. And then some more obvious things: social security numbers, driver's license numbers, credit card numbers. That is not shared with anybody. Every once in a while, you get this information for various reasons. Somebody pays online by credit card. Nobody else can see that. On electronic or email addresses, there is one exception for that. If a homeowner says, please send me the required notices for annual meetings, etc., by email as opposed to in writing at my mailing address, then other homeowners can actually get a copy of that electronic mailing address. There's some discussion about protecting that as well. I'm not sure if it'll pass or not, but if it does, it'll be effective July 1st. But right now, if someone consents to receive annual meeting notices, for example, just by email, that email address would be subject to inspection and copied by the other membership. But if they have not consented to it and they just scratch their email address on a form, that's still protected. It should not be shared with anybody. All right, budgets and reserves. We'll skip over the condominium provisions and go straight to HOAs. All right, so you're coming up to budget season and usually October, so we're still pretty early on in the process. But as you know, because you have a lot of people that participate in the budget process, and you even have a finance committee that's going to be assisting in this, your budget should include some general information, including estimated revenues and expenses, all fees that you may charge for recreational amenities or anything else, and reserves. So as you know, your charter was amended this year or last year in order to set up some reserve requirements. And so your required reserves and your governing documents will be included in your budget, including whether it's a pooled or straight line accounting system. You must provide each member with a copy of the annual budget or written notice of that a copy of the annual budget is available at no charge. And this is coming up. You're going to see a couple of deadlines. You're going to see a couple of deadlines that I'll address for the financial reporting. I normally go over the guide to understanding HOA reserves, but you're easy because your charter now basically tells you what you're supposed to do, and you've made this decision to include certain items as reserves. So in talking about it, I would call the reserves required by the charter mandatory reserves. The board can add additional reserves as it wants to. Those will be discretionary. So a later board can undo them, but your mandatory reserves, your required reserves cannot be undone. They can be modified as to funding if a majority of a quorum of the membership chooses to waive or reduce the funding for it. That's always an option for the membership, but it is a membership vote as opposed to a board vote for your mandatory reserves. Again, for your discretionary reserves just created by the board without requirement, the boards are free to change, modify, or even undo them. All right, so I have a built-in break for questions, but we're going pretty quick. Do you have any questions so far?
As you were reading this, I was trying to follow along in my book, and I thought, why are they captioning 718? And then I got the book from the Condominium Association. I don't know if everybody else does.
Yeah, we all do.
Yeah, we all do.
Oh, I'm sorry. We have a whole booklet of HOAs. I don't know why you got the condo one.
Oh, if we could get one that.
All right. So, yeah, there's a whole setup for HOAs.
Yeah.
Oh, got it.
All right. I'll wait for a second to make sure everybody gets that.
See, you know, I was
Yeah, you own a condo.
I need one also today.
You're welcome to have both. I provided both because that's normally part of the class, but really for our purposes, the main thing we should be following along is the HOA manual.
Thank you.
Sorry, I should have just asked you at the beginning. I didn't think that would be all right. Any other questions? All right, then I'll keep moving. And I apologize for those that have seen this before. It's not much different than what we did before. All right, financial reporting for both condos and HOAs. This is going on right now. You have a requirement in the statute that within 90 days of the end of your fiscal year, or on a date provided by the bylaws, you have to prepare and complete a financial report. That financial, so it's within 21 days after the final financial report has been completed, and no later than 120 days after the end of the fiscal year. You either have to mail or hand deliver or let the homeowners know that the association's financial report is available for inspection and copying without charge. So in other words, you can't charge for anybody that asks for it. These are kind of hard deadlines. I know every once in a while I have an association that slightly misses it. I just say do the very best you can. But clearly the goal is to hit this deadline because it's a statutory requirement. Your financial reporting is affected by your annual revenue. You have greater than $500,000 in total revenue, so you're required to prepare an audited financial statement. You have the option, if you wanted to ask the members to reduce this requirement. There's really not much reason to do so, but if they ever wanted to, you could save a couple of dollars by reducing it to a lower level. But I don't think you've ever done that. I wouldn't necessarily recommend that. I'll skip over the condominium financial reporting and go straight to homeowners associations. As I mentioned before, you can do a higher or lower level. There's no higher level, so there's no purpose for voting for that. A lower level will require a petition by the members and then a meeting within 30 days of receiving the petition to vote for the lower level reporting. Contracts and bids, we'll skip over the condos and go straight to the homeowners association section. All right. If a contract requires payment by CROA that exceeds 10% of your total annual budget, including your reserves, then you're required to obtain competitive bids for the materials, the equipment, or the services. And I emphasize this to everybody. I'm not so worried about you all, but I always emphasize you're not required to accept the lowest bid. Not with you all, but I've been to other association meetings where members, strongly question why the lowest bid wasn't accepted. And I think from your experience, you know that sometimes there's issues with the lowest bid not accurately covering everything you want. And that's why I put the reminder in there. There's going to be situations where you're going to be carrying over an already existing bid. So it does not necessarily apply in that circumstance. But where you are looking to engage or enter into a brand new contract, as opposed to carry over, this is when this is going to apply if the value of the contract exceeds 10% of your total annual budget. There are certain exceptions to the competitive bidding process. Contracts with employees of the association. So if you were to hire an employee directly to work for CROA, that does not require competitive bidding. Contracts with attorneys, accountants, architects, community association management companies, engineers, landscape architects, etc., do not require competitive bidding. The reason why is because you're usually selecting these services and professionals based upon their reputation as opposed to price, whereas a lot of times the landscaping contract itself, price is a bigger factor. In addition to this, if the business is the only source of supply within the county, not required to get competitive bids. And as I say again, you do not have to take the lowest bid. A couple other exceptions. A contract that you entered into before October 1st, 2004, and any renewal thereof is not subject to competitive bidding. The reason why is because the law that required competitive bidding for HOAs took effect October 1st of 2004. So they didn't want to undo any contract. We're at 16 years. There's probably not very many of them left. It's possible you have one, I don't know. But it's not required for renewal to be subject to competitive bidding. Another new change that was applied a few years ago, which is, I think, very beneficial, is if your contract allows you to cancel it on 30 days notice for any reason, so it's a no cause termination notice, you're not required to get competitive bids. And so basically this means that if for any reason you all decide to cancel a contract and it has a 30-day no cause cancellation, you just give the 30-day notice.
Tom, we can't hear you.
Okay, let me know if you can hear me now.
I think you're back.
Okay, can you hear me?
Yes.
Okay, so I'm pointing out that you have an exception for competitive bids. You do not have to get a competitive bid for a contract that allows you to cancel it on 30 days notice for no cause. So that just means that you decide one day that you don't want to work with the contractor anymore. You mail them a 30-day notice saying your contract is canceled effective 30 days from this notice, and then it's canceled. There are some contracts that try to mask themselves as this. They say, well, if you have a problem, you give us a notice of the problems, you give us 30 days to cure the problems, and then if we don't cure them, you can send us a final termination notice. But the problem with that is they can argue whether or not they cured the violations or breaches of contract. That's not what's meant by this. It's a true 30-day no-cause termination. And so if you have that in a contract and you're satisfied with the contract and the contractor, then you're not required to go, pardon me, through the competitive bidding process. But it has to be no cause, just giving them 30 days and you're out. Otherwise, if the value of the contract exceeds 10% of your total budget, then you would have to go through the competitive bidding process, with the exceptions for attorneys, architects, management companies, et cetera. All right, collections and assessments. This is for both condominiums and homeowners associations. You're allowed to charge interest at the rate allowed by your declaration. The highest rate is 18% simple interest annually, and your charter allows for 18%. You may also charge a late fee of $25 or 5% of each delinquent installment. So if you have quarterly assessments, then if a homeowner misses a quarterly assessment, then in addition to the interest, you can charge the late fee. Owners are liable for all assessments which come due while they're the owner. And if they're co-owners, then they're jointly and severally liable for them. In addition, if somebody buys a home without curing or taking care of any past due assessments from the prior owner, then they're basically walking into or buying into the unpaid assessments of the prior owner, with an exception for banks when they do foreclosure, which I'll talk about. Owners every once in a while will say, hey, I don't use the pool, so I should reduce my assessment by that amount. That's not how it works. When you buy into CROA or any other community, you're buying into the full assessment, whether you use the amenities or not. Sometimes we have issues, or your collection company will have issues regarding how people make payments when they owe assessments. So I like to give an example of how partial payments are applied and why it's important to understand it. So let me give you an example where a homeowner might owe $1,000. And that $1,000 includes $500 in delinquent assessments, and the rest is a combination of $500 in attorney's fees and costs, late fees, and interest. Sometimes you're going to get homeowners that get this $1,000 bill, and they're going to say to themselves, well, I'm just going to pay the $500 in assessments and make the association try to collect the rest of its attorney's fees, late fees, and interest. So they'll write a check for $500, and you or your collection company will get the $500 check. And at that point, you're going to be doing what the statute tells you to do, which is you're going to apply the $500 to interest first, then to your late fees, then to your attorney's fees and court costs, and lastly to delinquent assessments. And so when this happens, even if a homeowner says, please apply it to my assessments, not to the attorney that's writing me the collection letters because they don't want that attorney to be paid, the state says that's not how it works, regardless of whatever restrictive endorsement a homeowner puts on the check or on the letter accompanying the check. It's applied to interest, then late fees, then attorney's fees and costs, and finally to assessments. And there are two reasons why it's done this way. And it's important to understand when you're talking to homeowners who may be complaining about their collection account. Number one, the only thing that can earn interest or accrue interest is the assessments. You can't charge interest on attorney's fees, late fees, or interest on interest, because remember, it's simple interest. So it's not fair to the association that somebody can pay half of what they owe and direct it or target it to assessments so that you're not still allowed to collect the 18% interest on the unpaid assessments. And the other reason is it's not fair to the association to have to go to court and have to concede that you're arguing about attorney's fees as opposed to the actual assessment. As long as there's any dollar owed on a homeowner's account, it's the assessment that's owed because that's the last thing that gets paid off. So when you have homeowners that come in and say, hey, I paid your assessment, but I didn't pay your attorney, you have to go to them. It's just important to understand that, in fact, they paid the attorney, they didn't pay the assessment, or they paid the interest, not the assessment, or the late fee, not the assessment, because that's the last thing that's applied to. And so that's a requirement by statute. There's no discretion on it. And so when we talk to homeowners, when we're involved in collections, we'll remind them that any partial payment is going to be applied that way. We show that in any statement that they've received, showing that they paid off a certain amount. and what's still left. And so does your collection attorney. All right. What happens if a homeowner doesn't pay? The association has the right to place a lien on the parcel, and it relates back to the beginning of what they owe. And it's also going to include anything that comes due afterwards. And it'll actually say it on the lien. It'll say that this includes a certain amount and any subsequently accruing assessments. So we really are only required to record one lien. We don't have to re-record a lien every time there's a change. With regard to first mortgage holders, which means the bank that offers the primary loan for a homeowner to buy their home, the lien is only effective from the date of recording of the lien. So you can't go back and say, well, our lien is somehow superior to the first mortgage lien, because it's not. And to kind of give you a picture of lien priority, number one in the world is property tax charges. So if you have a property tax on a property, if it's not paid, that's number one. That wipes out any first mortgage, second mortgage, or CROA lien. Number two is going to be the first mortgage lien. Number three is going to be CROA's lien. Number four is going to be the second mortgage. So we're actually superior to a second mortgage. And then any other mechanics liens or other liens, except for possibly a federal tax lien, depending on which court you're in. If we're in state court, we're number one. And if we're superior to a federal tax lien, if we're in bankruptcy court, the federal tax lien is superior to us. The bottom line is we can record a lien even if the property is considered homestead, and CROA has the authority, like every other homeowners association, to foreclose and take title to the property if necessary, if payment is not made. As I mentioned, the lien secures everything that's already due, plus anything that comes along. For condos, their liens are only effective for 1 year, but for HOAs, you have a 5-year statute of limitations to enforce the lien. And so you have 5 years from the recording of the lien to file a foreclosure action or to foreclose on the lien and take title. Notice requirements. There are a lot of notice requirements for initiating an assessment collection action. So if you think about it, you all start with giving your annual notice of assessments. So you tell everybody, okay, January 1, this is how much you're going to owe for the year, and these are what the quarterly assessment payments are going to be. If they don't pay, you typically send out a courtesy notice or reminder. Hey, you didn't pay, you need to pay, and here's your courtesy notice or reminder. At some point, you're going to send out what's called an intent to lien notice if the homeowner still hasn't paid. So at this point, this is probably their third or possibly fourth notice of non-payment. For CROA, you give a 45-day notice telling the homeowner that if you do not pay your assessments, your interest, your late fees in full within 45 days, then CROA can record a lien against the property. If the owner fails to pay, then at that point, after the 45 days expires, you can record the lien, but you still can't file a foreclosure lawsuit. Now you have to send a second notice, and that second notice gives the homeowner another 45 days. It says, okay, we recorded a lien against your property, and at this time we have the option, if we want to foreclose on the lien if you do not pay us within 45 days. So this 45-day notice expires, and only after that.
Are you there?
I'm still here. Can you hear me? I'm still here. Can you hear me?
No. Try again.
Oh, can you hear me?
Now you're back.
Okay, good. So I was covering if you record a lien against somebody's property, then you have to give a second 45-day notice before you can actually file a foreclosure lawsuit. So by this time, they receive five, possibly 6 notices, starting with the original annual assessment notice to the final notice that if they don't pay, they have another 45 days to before the association files a foreclosure action. And you can see that there's a lot of built-in delays. So if you have a 30-day courtesy notice and 2 90-day intent to lien, intent to foreclose notices, you're at least 120 days. And honestly, you're probably more like at 180 days, depending on the delays that take place for making decisions and authorizing certain actions. So a homeowner who does not pay their January 1 assessment may not be subject or eligible to have a foreclosure action against them for the full 6 months, at which point they've probably missed 2, possibly 3 assessment payments. So it's important that we make sure that we're being diligent and giving homeowners notices so that the association has the option, isn't required to, but has the option of moving forward with a foreclosure action if you feel it's appropriate. These notices are sent by certified mail as well as regular mail, so we make sure that homeowners have every opportunity to receive a notice several times before any action is taken against them. If the association does not follow the proper notice requirements, then either the association will not win or it may not be able to recover its attorney's fees even if it does win. And sometimes those attorney's fees exceed the value of the assessment, so that becomes a problem. So we want to make sure that we follow the notice requirements, even though I have some clients that say, hey, can we just skip this? The answer is absolutely not. Estoppel letters. When homeowners sell their homes, they ask for an estoppel. And that estoppel basically tells them, is anything owed on the property and are there any violations on the property? And so you all are very diligent about making sure that any new owner is aware of the existing and unresolved covenant violations. It used to be the time frame for providing estoppel letters was 15 days. It was reduced a few years ago to 10 days. You're required to designate somebody that's supposed to receive estoppels. You can provide estoppels by mail or by email. A lot of them are provided by email. They're effective for either 30 or 35 days, depending on if they're emailed or if they're mailed. And there are some caps on bulk estoppel requests. So if a builder owns a lot of undeveloped lots, for example, and they ask for estoppels, then there are some caps on the charges that we can put in there. Otherwise, we follow the maximum allowed, which is no more than $250 for an estoppel, and an additional $150 may be charged if the owner is delinquent. I actually think that your charges are significantly less in the current management contract, but those are the caps in the statute. What happens if a bank forecloses and takes title? This happened a lot in the Great Recession, but it still happens. And it's important to know that unlike regular owners that may be buying from one to the other, they do or don't get an estoppel. And if they don't pay off the estoppel amount, they're responsible for everything. A bank can actually, and I say a bank, I mean a first mortgage bank, first mortgage holder bank or first mortgagee, who ends up foreclosing on a property and taking title, their exposure to association unpaid assessments is limited. By statute, it's the lesser of 12 months of unpaid assessments or 1% of the original mortgage debt. And this also applies to condominiums. So it doesn't matter if it's a single family home, a townhome, or a condominium, it's always a lesser of 12 months of unpaid assessments or 1% of the original mortgage debt. So if a bank forecloses, the bank takes title, gets a certificate of title, then it has 30 days to pay off this amount. So what they're supposed to do is contact you all through management, get the payoff amount, determine if it's the lesser amount is the 12 months or 1%, and then make that payment. It's important to know that second mortgage holders do not get this benefit because, as I said before, they're inferior to the CROA lien. So they don't get any exemption for the full amount owed. If a second mortgage holder forecloses and takes title, they owe the full amount. Just like the statute says, if somebody buys a property, they don't take care of the unpaid assessments. They're walking into the full amount of unpaid assessments. And they're also walking into any existing covenant violations if they weren't taken care of prior to the sale. You have the right, as every other homeowners association does, to collect rent from tenants of delinquent owners. And there's a pre-suit process and a post-lawsuit process. So in the pre-suit process, if you identify a property, the owner's delinquent, and they have a tenant, you have the right to send a letter to the tenant informing them that their owner's delinquent and that they should redirect their tenant rent to the association and to continue to do so until CROA is paid in full. Now, in practice, very few tenants do this, maybe 1 in 10. And the reason they do it is because they know that there are privileges to use the pool and other amenities may have been suspended, and so they're encouraged to do it. But as you can imagine, a landlord will tell their tenant, look, if you pay to the association instead of me, I'm going to evict you. They don't actually have the right to do so, but you can understand why tenants might be scared of this. So maybe 1 in 10, 10% may decide to respond positively to the letter. The others probably do not. In the post-suit process or in the litigation process, if we're aware that there's a tenant in the property or your collection attorney is aware, then they can apply to the court for an order directing the tenant to pay CROA instead of the landlord or the homeowner, in which case, essentially, you just wait for the tenant payments to go through, catch up on all the unpaid assessments, and you can close out your case without actually having to do a foreclosure, which is a benefit. More tenants will respond to this court order, but not everyone. You can still imagine that some tenants will say, look, this is too much of a hassle. I don't want to deal with this. I'm not going to renew my lease because of this. So by the time they may get around to doing something about me not paying, the time will have passed. And when I say time to get around to doing something, it's important to note, as I mentioned before, that a tenant is immune from any claim by the homeowner or landlord about them paying rent. But you have the authority, if you wanted to actually evict a tenant who is living in a delinquent owner's home and not paying the rent to the association as directed basically by the law. But I don't recommend using this in very many cases unless you have a problem tenant that's living in a delinquent homeowner's house and you have other reasons that you might want to remove the tenant. It's better to leave the tenant in there and just try to collect the money, because most of the time, and I say 90-something% of the time, the homeowner will end up paying the association. So it's not necessary to go through the eviction action. All right, we're at our last topic, suspensions and fines. And I warn you of that because we kind of end abruptly. All right. So when you have homeowners who violate your governing documents, and I'm not talking just about non-payment of assessments, but I'm talking about architectural changes without review, without approval, not maintaining their property and things like that, you have the right to suspend owner's rights. In addition to suspension for violation of the covenant's restrictions, you can also, if you want to, levy suspension for non-payment of a monetary obligation, which basically is assessments or fines or something like that. So there's two reasons why you can do it. So the general violations are for non-payment of money. If you have a violation for non-payment of money, then the suspension can last for as long as the homeowner is delinquent. When they pay you in full, that type of suspension is lifted. For violations regarding covenant violations for not maintaining the property, for example, usually the suspension is limited to 60 to 90 days. When you look at what you can suspend versus what you can suspend uses of recreational facilities. That's pretty common. If a homeowner were to pay you pay for their cable services through you all, which some associations have that, you could suspend their cable, but you certainly cannot suspend pretty much anything else. I know homeowners don't pay their utility services through you, but if they did, you can't suspend their parking privileges. You cannot suspend access to limited common elements. So for a condominium, you can't suspend somebody's access to the balcony or the patio, for example. So basically for CROA, you're looking at the recreational facilities. You can also suspend an owner's voting rights if you want to for non-payment of assessments if they're more than 90 days delinquent. For condos, the debt has to be more than $1,000. There's no minimum threshold for CROA. In order to suspend somebody's voting rights, you actually have to have a board meeting where you vote to suspend the voting rights, and then you have to send a letter, or if they accept email, by email, letting them know that their voting rights have been suspended. If you don't have the board meeting or you fail to send the notice, then the suspension does not take effect. If you do suspend somebody's voting rights, then you don't have to count them towards a quorum. So, just saying a number, if we had 100 homeowners, obviously you have more, and you lost one because of the voting rights being suspended, then your quorum is your percentage out of 99 as opposed to 100. You may also levy fines for violations. So we talked about suspensions, the additional and more common violation penalty, fines. For CROA, you can levy fines up to $5,000 for a particular violation. The actual fine has to accrue at no more than $100 per day per violation. The statute says it's $1,000 unless otherwise provided in your governing documents, and your governing documents provide for $5,000 in the aggregate. If you have two fines, then each fine can accrue at the same time at $100 a day. And so you can have two fines, each accruing up to $5,000 for a total of $10,000. And then the consequences of not paying the fine: voting rights can be suspended, privileges can be suspended, collection action can be taken. Before you can levy a fine or impose a suspension, you have to provide at least 14 days written notice of the Covenants Committee meeting, at which the Covenants Committee is going to review and approve the proposed fine or suspension, and the homeowner has the opportunity to attend the meeting and present a defense if they want to. They can present documents, photographs, or testimony to argue against imposition of the fine or the suspension. As you also know, your Covenants Committee cannot consist of board members, which it does not. or family members of board members. It's a reminder that the committee requirement does not apply when you're suspending somebody's voting rights. That's based solely upon money. It's not based upon whether or not they actually committed a violation. There's really no question, and the state doesn't require you to do much more than just determine from your accounting records that they failed to pay. All right, that's it. So I apologize for the sudden end to it. Do I have any subsequent questions?
Uh-oh. Jessica and Susan.
Microphone, have to go to microphone.
Here you go.
So let me just say this. So normally I'm there with you and I get a lot of questions. So I'm actually thrown that you haven't asked me a lot of questions. Now, maybe over the course of knowing me, I've answered most of the intermediate questions, but I would just say, if you want to ask me questions about this, please do so. If you want to ask me other general questions, we have a little bit of time, as you know, and so I'm happy to answer any other general questions that you might have. So if it's beyond just this, please feel free.
Regarding the covenant fine, we mentioned intent to use that could be associated with like unpaid assessment. I just wondered if that same thing could happen with a covenant fine, and if so, is there a specific amount that would need to be after that process to include?
Okay, so I heard part of the question. I heard about covenant fines, but I wasn't able to catch all of it. I'm sorry.
Sorry, probably not close enough. So for covenant fines, is that process of intent to be still applicable? And if so, is there a specific amount that needs to be accrued in the fine in order for that process to take place?
Okay, so I think I understand. So I think the standard, you're going to have. Well, I'm not sure I caught the whole question, so I'm going to answer generally, and then if I miss something, please just ask me to follow up. So for covenant violations, I've seen some associations that will apply, different amounts to different violations. But my general advice is apply the $100 a day per day. That's just my general advice. Look, I get that there's certain violations that you might not want to do that, but generally I say just go ahead and apply the $100 a day because that's a cap. It's going to accrue over a lot of time, even at $100 a day before you get to the $5,000, at which point you can go ahead and impose that. Your documents allow you to apply up to $5,000 for any violation. And then it's a question of, well, at the end of the day, you want to enforce the full $5,000. That's entirely up to the board's discretion to do that. Sometimes you have homeowners that subsequently comply and you recognize that and you can address that. You also have homeowners that don't comply at all and they force you to go to court, in which case you're much less inclined to forgive any part of the $5,000. Also, you have homeowners that have repetitive violations, they're chronic violators. And although you might be interested in helping or considering for one-time violator, some sort of exception, if they've subsequently complied, if you have a chronic violator, you may be less inclined to do so. But I think I'm answering your question to say that, my recommendation is usually apply the $100 a day because it's going to take 50 days to get to 5,000. And then if you ultimately want to enforce the full 5,000, that's entirely within the discretion of the board. And if I missed any part of it, then please feel free to ask a follow-up question.
Suzanne is going to try.
I have a really loud voice, so the question, Tom, is yes, we understand the finding process, and you can take the fines to a lien if necessary. But is there a minimum amount?
I'm sorry.
Point there was $1,000 minimum before you could take that fine.
Yes, I'm sorry, I missed that. Yes, you're absolutely right. So the statute says that you cannot lien for less than $1,000. So once the fine equals or exceeds $1,000, then CROA has the right to convert that unpaid fine into an assessment and collect it in the same manner as any other assessment, which includes a lien. So the statute says the word lien, but I think of it as convert it to an assessment, which is a lienable charge, and then record a lien on it. You need to give the owners notice that you're doing that. We've talked about that. That's already built into CROA's process. But I'm sorry, I gave a long-winded answer to the question you didn't ask. The simple answer is yes, it's $1,000.
Thank you. Thank you.
Tom, is this a good time to talk about conflicts of interest?
Sure, I'm happy to. Yeah, we can talk about that. You just want me to just kind of jump in?
Yeah, why don't you jump in about when is a good time, what would count and when a board member would want to recuse themselves from a subject?
Okay, so we have a lot of information on conflicts of interest, and some of it was actually added to and addressed in your charter and bylaws. And some of it's addressed in Chapter 720, the Homeowners Association Act. And finally, we borrowed some of the information in Chapter 617, which is the not-for-profit corporation statute. So if you don't know, CROA is governed generally by two statutes, Chapter 720, the HOA Act, but it's also governed by Chapter 617, which is the not-for-profit corporation statute. And if you were to compare 617 to your bylaws and vice versa, you're going to see a lot of similarities because most association bylaws will incorporate and add or basically repeat what 617 says. So reading Chapter 617, Chapter 720 in your charter together, in your bylaws together, it establishes situations or recognizes situations where a board member may have a conflict of interest on a matter in front of them. So generally speaking, a conflict of interest occurs when there is, for example, a contract that's being presented or considered by the association's board, and a member of the board or their spouse or family member has a financial interest in that contract. All right. So common example, if you were looking at landscaping contracts and one of you all owned or had a financial interest in a landscaping company, or your spouse or a close family member had a financial interest in the landscaping company, then you need to do the following things. Number one, you need to identify to the rest of the board that you have this conflict of interest, that you in fact have a financial interest in consideration for the particular contract. So that's number one. Number two, when it comes to the contract, whether you have the direct financial interest or your spouse or close family member does, then you have to abstain from voting on it. So if it's being considered for approval and there's a motion and a second, you're allowed to speak on it. You can say things positively about it, but you're not allowed to vote on it. You cannot cast a vote in favor of it. In addition, there's a statutory requirement that if you're going to have a vote, then although we're not going to count your vote, the state wants to see that 2/3 of the rest of the board has given the thumbs up to the contract. So those are the three main things: identifying that you have a financial interest and a conflict of interest, abstaining from voting, and the requirement that 2/3 of the rest of the board approve the contract. Finally, if a contract is entered into where a board member has this direct financial interest, then at the next membership meeting, this is only for homeowners associations, it doesn't apply to condos, but for the next membership meeting for CROA, any member can make a motion to cancel or discontinue the contract. And if there's a second and a majority of a quorum of the members vote in favor of canceling the contract, then the contract is terminated or canceled effective the date of the meeting. Anything that was earned before that membership meeting vote still gets paid. There's still an obligation by CROA to pay for the services provided, but that contract would be canceled, and CROA would then have to turn around and find a new contractor to provide those services.
All right, Tom, let me ask a specific question. Obviously, Celia's son runs the clubhouse at Artisan Park. So we have things that come before the board almost every single month. It could be fixing a fence, it could be this or that. I don't think he has financial interest in it, but obviously he's working there and is coordinating. So how does she as an individual and we as a board think about everything that comes up to be approved on a monthly basis regarding Artisan Park Clubhouse?
Okay, so I mean, it's not much different than if a board member was voting in favor of some maintenance that's going to benefit the neighborhood in which they live. So I don't really see Celia's vote in favor of spending money for Artisan Club, like with the clubhouse or the park or anything in the service area, is generating a conflict of interest. Any more than if you improve the trees or cut down or trim the trees in a certain area for somebody else. What I'm looking at is truly a direct financial interest, where if you approve a contract, with someone's company, then they're going to obviously financially benefit, and that's worth the abstention. But just generally, I've got a Artisan Park service area budget where they've budgeted for certain maintenance work, and the CROA board is approving the recommended spending by the Artisan Park Service Area Committee. I do not view that as a conflict of interest any more than I would if anybody else was serving on a service area committee as well as the board of directors. I don't see that as a conflict of interest because it's benefiting more than just them. It's benefiting other members of the association. And in fact, there's a couple of cases that say, look, if you're benefiting a group of homeowners, it's not just the one, then that should not usually generate a conflict of interest.
Okay, so then let me follow up. Your answer actually surprises me, but should you ever, you've got a legal answer. What about the perception of fairness or unfairness? Maybe you say you don't care. I think what I'm hearing you say after you answer that question is we as a board don't have to worry about a 2/3 rule or anything like that. If Celia, as a matter of practice, abstained from Artisan Park votes and we only had 6 people voting, is that good practice, bad practice, or you don't care?
Okay, so yeah, there's always 2 answers to this. One's the legal answer, do you have to? And so the short answer is you don't have to for those sorts of things. If you want to, because you want to avoid an appearance of impropriety, I think that's the official phrase for it, then you're fine abstaining. If you want to give a reason why you're abstaining, you're fine doing that as well. I do not expect to see a 2/3 vote for it. And then, the devil's in the details. If there's a particular issue that you're particularly concerned about, whether you discuss it with the board or you run it by me, I'm happy to pass on it, pass a view on it. But just generally speaking, you do not have to do that. But if you want to do that because you think it looks better, you're fine doing that. And you're certainly allowed to. You can abstain for, reasons, that are solely yours, even if you're not actually required to abstain.
Okay, so I'm going to ask a different question if no one has a follow-up on that. Celia is an administrator on one of the back porches, maybe the front
Yeah.
porch too, I don't know. Does that create a conflict for her or for the board? How do you think about it? And I don't know if you're on the porch or not, but on the porch,
I'm not.
administrator, you make comments, et cetera, et cetera. So how should she remain in that role? And I'm not trying to pick on you, I'm just trying to break up
That's
things. Should she
understandable.
remain in that role? How should she think, if she does roll, how should she think about what she does? And for the new board members, how should they think about how they communicate on the porches or other social media things?
All right, so I guess since I'm not on the back porch, I'm not, for various reasons. I guess I would just say, is the question related to, as an administrator who can, I guess, and what is your powers as an administrator? What do you normally do that might?
I'm the moderator, if somebody reports inappropriate comment, and actually there was a little commotion going on yesterday about the porch sale that turned really political, and people kept sending me reports and alerts, and I just sent them off to Leslie Kipple because he's the admin. I stayed adamant. I said, Leslie, you need to take care of this. I just approve if people want to
So you
join.
you can delete people though, or you can mute
Oh, I can
people.
block people?
Yeah, she can block people. You can take down posts.
They
You can
can't,
post. Yeah.
they cannot, if they have me blocked, they can't join. So they have to unblock me. If someone makes a comment that I think is going to cause a big explosion, I just turn off commenting. Just so if the question is answered and the comments are turned off, it doesn't take 30 heads of its own. But if I need to remove myself from it, it's that simple. I remove myself from it. But
Okay.
I feel that communication with the residents in Celebration is a big part. And that's, technology and everything. This is how they get a lot of their information. And it needs to be answered correctly. You can't just say, oh, I heard this, I heard that, I heard this, and I heard that. It has to be the right information out there. So.
Okay.
Right.
Yeah, so in hearing that, I would say the following. I would say, number one, you're not required to surrender your administrative or administrator duties and powers. You're not required to, all right?
Because I get
So if-
paid a lot of money for that.
Okay, all right.
Like CROA.
Only kidding.
So, but the only concern, I always look at it from a liability question. So, okay, so you have this power, now you're a board member.
Mhm.
How will others view you exercising this power while you're also a board member? Now, I know that your administrative powers on the back porch are separate and apart from your service on the board, right? So it's important that in every circumstance possible, it's made clear that your actions as the administrator for back porch are not related to your service on the board. And by that, I mean, if anybody suggests that they're related, it needs to be made clear to them that they're not. And you know that the board has no say over how you're going to enact your administrative duties. The risk is always there that somebody will mistake your administration of the back porch with your service on the board of directors, and they may make claims that are directed at you as a board member and to CROA because you're a member of the CROA board. So there's always that risk. It's not that it's true, but that there's this risk. So I would just say keep that in the back of your mind when you're deciding whether to continue to do your administration or how you communicate with anyone. Because if somebody starts addressing you as a board member, you want to make it clear that you're not acting as a board member. You may even, if people are already aware that you're a board member, which some of them should be, you may want to put some sort of disclaimer in there to make it clear that this is not, your service on the board does not mean that CROA has any control over the back porch, which it does not. But it sometimes helps to make that or add that clarification so no one mistakes this as now the board is directing you to do something.
So I think this is going to fall into a communication workshop without a doubt.
Yep.
But I keep notes. This is my notebook from last year's session where we had our organizational meeting. I often keep a lot of notes of that. And I'm intrigued that Jackson hasn't jumped in yet on any communication. I'm very excited to hear what you have to say about this. But I know David once upon a time said nothing, when it comes to having communication on social media. Didn't like it. I know Jackson wanted any social media communication to actually be run by the entire board before it's posted, as well as a excerpt that says, this is me speaking on my own, not as a board member. So it's just really interesting. So this is the other side, I guess you would say, that I had a struggle with in the past, was because I would say things, even if I'm speaking as myself, even as a
As a
volunteer,
resident, you would
and
say.
it would go ahead and cause some controversy here. So I'm very intrigued to see where
Well,
this goes.
and I did the same thing because it was when I was president, you were secretary. Unfortunately, the reality of the matter is in this town, people know who's on the CROA board. I mean,
Well, I should
Celia
hope
and everybody
so.
else,
They
it's
elected
on the
us.
porch. I'm
Yeah.
not criticizing. I'm just saying
Yeah.
it's on the porches. People know who it is. And as soon as I've been called out, I've seen Kevin be called out. And by called out, I mean,
Okay.
hey, Brian, you're on CROA. What's this? Hey, Kevin, you're on CROA. It's beyond a shadow of a doubt. People are going to Cecilia's on the porches for legitimate reasons. But as soon as you're there now, you're going to be seen as speaking on behalf of
The board.
CROA. There will
Whether
be
you
zero
want
doubt
to-
about
whether
that.
you want to
And-
or
say you're
not.
not.
Yeah, even when you
Well,
say
yeah,
you're
you
not.
can say you're a frog jumping. It doesn't matter. You're one of
You're
7
CROA.
CROA members, and they're going to say, here's CROA's voice on this issue.
Well, I
And
have
you will
to-
get called out.
I have to say, if we're talking about that, Greg Felak is on the CCD board, and he makes it, he doesn't use the CCD position. People know he's on the CCD board. When he makes comments, they're comments in general. But I do like what he does as a CCD board member is post the agenda for the residents to see. And
Agreed.
it's very important. And we always talk about modern day technology. And the residents get very frustrated that they can't access the website. And if it's just out there and they see it, they'll know there's an issue. This way, if they have a problem, hey, it was out there, you saw it, why didn't you address it?
And And I think and I'd be interested, I think this is going to go to us setting communication standards, because I've seen him, my wife loves that he posts the agendas, and she knows I'm on the CDE
Yeah.
rep, so she tells me what I should think on a subject,
Because
which
people
is
don't
fine,
know.
because when Greg wants to get a hold of me, he doesn't do it via Facebook. He sends me a direct
Mhm.
text or a direct
Mhm.
email and talks about something as the rep and stuff like that to make sure I'm there. And so we're going to need if we're going to go down this path, we need a communication
We-
structure that we
And
follow.
also, people asked me the other day when I posted something on there, well, what's the meeting information number? And that I know not to post up there, that you have to get through town hall.
Right.
I just post the agenda and somebody says, well, where's the information on how to get on? It was for the town hall meeting. Where's the information? And I didn't answer that person because I was on the meeting, but I know not to give out the ID number for people to get onto our
Right,
Zoom.
they should just go to.
Right.
Right, they should go through the proper
Right,
channels.
so if they see something on that agenda they want addressed, or if they now need to go to town hall.
Cindy, and then, go ahead.
So years ago, before social media, Celebration had a website, and they still have it, but I don't even know if they have the forums on there.
No, they're not up,
So there's a
they're
forum.
dead. I think.
And we had a full-time employee who would monitor that, because there were several categories. You know, if he could answer the question, he would. Sometimes it was just, yeah, I've got something to sell, blah, 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 not an issue. But anytime anything came up there with the full board, he would go to who was responsible, either the board or something from the management company, he would go to them to get the answer to put on this front porch. I would say the solution to this problem is because now the community has a Facebook page to somehow train these people to go to the Celebrations Facebook page or the forums to get these questions answered.
They're not gonna do that.
They're not going to do it.
So what- so what-
So-
It won't be, it'll never happen. We've
I
tried.
could-
There is a way.
Yeah.
That's a workshop.
Well,
And it's going to be a workshop.
It's a
workshop. There is a way, and I believe, with a change in management, that it will be possible and that they will be more.
You mean the change in executive director
I
and
think
community.
it's gonna change
yeah, clarify
by
that.
these great individuals here. No.
Good, Neil wasn't
The
listening.
change has happened.
Right.
And I believe that we have a different mindset in our management at this time that is looking to get communication to happen. And there's like, that issue is it's not.
Yeah, it's very
Yeah.
So there is a
important
way
that the
to present
community
it forward.
knows
I will be
what's going
presenting
on.
it then.
Jackson had something to add?
Well, Kevin asked about my opinion. First of all, you probably should go back and read Gentile versus the State Bar of Nevada. It's a Supreme Court case that I argued in favor of free speech. I'm in favor of free speech. I think that even if Kevin and I don't agree, Kevin has the right to post his comments on Facebook or any place that he wants. The point that I tried to make 2 years ago was that those comments should carry a disclaimer that says, I'm a CROA board member, but I'm not speaking for all 7 board members. And I think that's appropriate for Celia in this situation to say, I'm a moderator of this site and these comments are my personal comments. I don't participate in the back porch or the front porch. I have a Facebook account, and in the year that I was not on the board, I posted on that account because I wasn't a CROA board member. My posting on those accounts will now, if there is anything, indicate that I am a CROA board member and I'm speaking on my behalf only. And that to me is probably the most reasonable way to continue to allow the free communication to occur without the misleading approach that suggests that any one of the 7 of us speak for anyone else. And so that would be my response, Kevin.
I don't think we're going to totally do away with all of us being on Facebook. I love the comment of, I'm not speaking for the board. I'm speaking as a personal, as my person. And that does solve part of it, but I do think we definitely need to workshop this and talk about how we do better at communication to the residents, for
Because they're
instance.
very frustrated that.
And that frustration should not be there. I saw the comment about the yard sale.
Yeah, it went from the
I
yard sale
saw.
to, whoa.
Welcome to, yeah.
No, it's
I
just like,
Yeah, I know.
it took a life of its
It-
own.
Oh, and it will.
And
and
I kept getting all these alerts
Yeah.
and
Usually
all
on
these.
Thursday or Friday nights around the time people are drinking wine, it could go great.
Yeah.
I have
So-
experience.
I thoroughly, we have to workshop this because we have to do better and partner with CCMC and our management company to make sure that they're getting communication out, whatever format that may be. Because it's not getting there and there is a frustration. And I realize that you're trying to address that as you a private individual as of yesterday and now a board member as of today.
But moving forward, is it okay, like Greg does, to put the agenda out there for the residents to see? It is their right. A lot of them, in just this year with the pandemic and everything, I realized how much people have on their plate. And if they just go on the back porch and see the agenda with no commenting, here's your agenda, communication. If
I
you
don't-
see anything on there,
I don't have
but
a
no
problem.
ID information
Yeah.
on how to log on, they have to
Right.
get their ID, because of course, on the back porch and the front porch, there's people that infiltrate that.
Oh,
and you
there's
don't
tons of
even know if they live
non-residents.
here.
I have no problem with you posting the agenda. That's
That's it.
public, and I think that's
Mhm.
information for the residents. But you might also want to post how they reset their ID and get their password,
Right.
like I just had to do because I couldn't find my
Right,
password.
so for,
I would say the agenda that's meeting now, they have the information on the.
Yeah,
agenda.
so be careful not to
So
post
I
it with the,
I would cross that off
Yeah.
and just post the agenda.
because otherwise we're gonna have
Right.
some
Oh,
Zoom
yeah, I know,
bombers.
otherwise we'll
and-
have,
Yeah.
Yeah, well,
More than one reason we need communication.
Yeah.
I think it's
Our-
important.
I have that as a note for a meeting that we're gonna schedule
good.
workshop. Okay. All right, anything else for Tom while we have him sitting there being quiet?
So just moving forward, when it comes to artisan, this way
Mm-hmm.
there's no issues or any concerns or people thinking anything. I'm just gonna completely remove myself from any discussion. Well, I guess I could discuss something.
You can
Says
discuss.
you can
it.
discuss.
If you just
shouldn't
remove
vote.
yourself from the vote, you
Yes,
take yourself
Absolutely. This
above.
way we know
um,
moving forward that,
Well, and just
That's
clearly
how it
say
is.
you recuse yourself or you're not
Mhm.
gonna vote, and then they'll make that a note of that in the minutes.
right,
And then
Yeah,
there's
yeah,
no,
yeah,
you know,
yeah, you'll just say you're abstaining from voting.
okay.
abstain. Thank you. Better.
It's easier just if we get it out.
Yeah,
And
no,
do we
that's why I
know?
wanted to bring that up. Is there
While we
anything?
have Tom and we still have 18 minutes of his time, we did not finish the prior conversation when we broke to go into this. Could we use, if Tom still got his 18 minutes, could we
the
excuse
executive
management
se-
for
I was gonna say
18
the
minutes and
executive
finish that
session.
prior conversation?
I think we'd have to exclude management and
That's
turn
right.
off the feed if that's. if
Yeah,
gonna
because
go
we're
there.
on Zoom feed right now.
Yeah, we just want Tom. Well,
Do we, if we, yeah,
adjourns, Then, I don't know, if we.
we ended the
Well, we wanna
meeting.
do another executive session for 15 minutes.
We didn't vote to
Is
adjourn,
that
did
gonna
we?
be posted for me?
we did it.
Not yet.
What did you say?
Because we
I
didn't
couldn't
vote to
hear you, Tom,
adjourn,
sorry.
Hold on, let's listen to what Tom.
Okay.
Can we do that, Tom? Can we close this meeting out and go back into executive session with you?
'Cause we
Yeah,
didn't-
as Jackson's pointing out, we didn't actually move to adjourn the executive session, so we can just pick it back up. Just tell me if
Okay.
I need to go back to the other Zoom link and jump back on that one.
I think, can you dump anyone off that's on there though, other than Tom?
And then this, and then the public meeting resumes at 1:30,
Yes.
right?
Mhm.
Is that what we're saying?
Right, we're
Yes.
saying we got 15 minutes left of Tom's time to finish the
So
other
is it,
meeting.
what do we have, 3 people on,
I guess so.
whatever it looks like,
Yeah, who, you're just,
or 2?
okay. Who was the one you just let?
So we just threw one person off?
Oh, it was the room.
Celebration Town Hall.
Yeah.
That's
So
it,
no one,
right.
so no one else was on.
No one else on.
Oh, no one else was on?
No one wanted to be trained.
Yeah.
It was such a hot topic. Okay. All right. If you could excuse us until 1:30.
Okay,
Thank you all.
thank you.
Yeah.
So we're not recording, but we
Yeah.
have Tom.
All right, and if somebody else wants to take this back, otherwise I'll just,
The front of it?
Front.
we're still on
Major
the front.
activities, capital improvements.
Okay.
Okay. There's really not much to say about capital improvements other than we're technically on hold, but we've asked for management to get updates on the field and what we're doing with the new, what the possibilities for all the layouts on the field and fulfilling pickleball and yard sports in yard for East Lawn and possibly Lot B. out of the field.
What I'm concerned about is it's March, whatever today is, third, fourth, whatever, fifth, whatever. And we can't be sitting around a month from now, having not discussed this, we're gonna have people freaking out.
I think they're already mad
Yeah.
about
They are.
pickleball.
So what do we do to move this much, much faster?
And we've had multiple workshops and a long evening workshop. Neil's worked on the inventory and has an update coming. So how do we move forward, make a decision? I mean, how do?
Let's start.
You, and by the way, thank you for the rollover directors. The new board will get our amended report with some updates from the previous workshop today. And it, at least in my, with minus one thing, Susanna has been struggling to connect with one engineer. I've been playing tag with another. And then I need those two conversations to happen before I talk to the most recent MBV. So that's the only supplement that will be forthcoming, but you guys will get that report today
Okay.
via either myself or Amber or Susanna. She's
And
just,
what exactly is going to be in that report?
it's, did you see you remember the first one that we submitted? There was a question about the legal requirement, if any, if there was to be a repurposing of the existing field. So we have Tom's opinion for you. There was a request with respect to field usage so that you guys can get a better understanding of kind of the sports teams and how the civic quarter has been used. So we have that with some graphs in there and some statistics for you.
Okay.
And then you also had asked for maybe some visual ideas of what fields might look like with pickleball. And what we have done is we have given you some of those on both, I think, one of the grass fields, but also lot B.
Okay.
And at any point, I mean, if you want my opinion, I'm happy to give it, but I'm not going to do it until the board's ready and wants it.
Is it possible for us to set up a 1-hour workshop at a point in the next? I mean, it sounds to me like what I just heard is you're ready to issue us something and you're ready for the board to have a conversation.
I think my team and I are absolutely ready to give you our opinion based off of previous year's reports, research, and then the most recent one we did. To an extent, COVID was good and bad for this because selfishly it gave me time to catch up. But we feel we're confident with what has been done historically, and then the most recent discovery from the board on the fields and the resources available.
Okay. So I agree with doing it as a workshop item. Do you think we need this as a specific workshop just to
Correct.
deal with
Yes,
this
yes.
report?
Yes.
I think it would
So-
get us huge brownie points to just have a capital improvement update workshop where, and this document, once we've looked at it, come back with any comments, could be posted in there. And then you can get your Steve Northridge's and all the other people who care, participate here, listen, and we're not ignoring them. If we do this in March, then we can have further follow-up and make decisions.
So traditionally, we have been doing workshops on Friday mornings. Could we do a workshop on next Friday morning, which is not on the schedule already, to cover that? And have it next Friday? Will you be prepared for the 12th?
We can. I don't want to commingle subjects, but as we get into meetings, I just want to be honest and vulnerable. By the time Fridays come around, most of us are mentally fatigued.
Mhm.
I'm not saying you have to do this, but I do think workshops, because they're more conversational based, if we could move them towards the beginning of the weeks, that would be ideal for us. But we are here to just do whatever is going to be best for the board.
Mhm.
Suggestion?
So yes, but when we start talking about future meetings and
Yeah, well, yeah,
schedules,
and that is.
right, okay.
yes, You are commingling subjects, but
I'm
we've already
sorry.
started. We've already started that.
Okay.
So a broader suggestion is, again, we have on the agenda talking about meetings.
Yes.
So maybe we embed that in meetings.
Okay.
Traditionally, we have not had a board meeting in March. The board workshops on Friday was actually last year. Before that, it was a Monday morning.
Right.
I don't know that Monday morning is a good time. So again, I would just defer that, and maybe we remember as we do meetings, we want a special workshop just on this, and that should be our first one. Maybe that's where we go.
We've already said so far that we need a communications workshop,
Yeah.
and then we also need this. So I agree. Let's table that for the meeting schedule.
And we'll do that
That we're
today.
going to do that. Yeah, we're going to schedule it today. I agree. Okay.
Just to be clear, though,
Yes.
we are going to receive a comprehensive document, bringing those of us that are new up to speed on what's been done. And when you mentioned, Neil, the engineers' reports, are you talking about the engineers that actually did the initial work on the fields? Are you talking about the engineers that came in to evaluate that? What are we looking at?
Both.
Both.
Yes.
And I don't want to wait very long to see that work because it seems like that's pretty critical to everything else that you're submitting to us. Am I correct in that assumption?
It might be. That's why we have to have conversations, because those reports and the plats and the reports from engineers previously don't actually answer the questions that came up early, well, at the end of last year, which was, is there construction defect is too strong of a statement. Are there deficits from how it was installed? From what I've researched, what I've read, it doesn't look like it to me, but I'm not an engineer nor a lawyer. But I need to have it's actually 3 engineers. It's the firm who created the plans, the plats. It's then the team that executed those plans. And then the most recent engineer who took the soil samples, who can speak to both of those. So it's actually 3 different groups that we need to get them to commit to calling us back. Again, we've been playing phone tag, so we're trying to be considerate of their schedule.
Yeah,
Mhm.
I understand in a busy world, phone tag is a thing, but as one board member, I would just tell you that I want to see the documents.
Oh,
And I want to see them sooner rather than later.
Oh.
I agree with the comments that have been made that this thing has dragged out a very long time. It seems like from the outside that there were several different options available. And I think in order to evaluate those as a board, at least for me, I'm going to need to see those options laid out clearly and specifically, and not kick the can down the road. So when we get to meetings, we can talk about when that happens, but that meeting needs to be a point in my mind where we've got that information and we can actually start to make progress on this.
Point taken. Committee resolutions, was that the only thing under capital improvements other than, yeah, I think committee resolutions, we need to review those annually, and also committee membership. I'd already asked Susanna to provide us any openings that we had or vacancies on committees. Yes, which she sent to me, so we'll have that available, which I'll share with you.
But does not everyone have to be reappointed or reapply?
Yes.
Mhm.
So at the April meeting, the resolutions will be updated, part of the resolution that you want to discuss, also the committee have input on what they'd like to see. And then we'll do a call for volunteers. And then the ones that are full, can do the applicants.
What I'd like to do, if we could, is do the committee resolutions at the April board meeting, because like, for example, finance, I think our meeting was the second, third, something like that. And I know, because last year's resolution said the treasurer is the chair, I want to change that so that the chair is actually somebody on the finance committee and the treasurer is part of it and stuff like that, so that we build, change that. So I think we need to review them all like that.
Can we ask the current committees to give ideas about what the resolution should be, so that we can vote on the resolution and the membership in April?
Yeah, they're
Both,
together, and
both.
we usually send it to the committee first and say,
Sure.
please review this as a committee, and we have any suggestions, changes, and then they send it back, and then, we'll have that.
It seems to me it was delayed last year or the year
Yeah,
before.
I
It's just,
agree. And Cindy, I'll
we need to get on
take
with
care of
the
that, and
committees.
then I'll
Yeah.
coordinate with you how everything going on, so we just get
For the finance
transition
committee.
moving.
Okay, so who handled that last year? That all was taken care of through management?
Management just coordinated with all the committees.
Okay, so
last
that,
year
so we
was the
can,
beginning of pandemic, so.
That was right after we came back, yeah, but they still got approved.
so we will continue, we will count on that for the April board meeting then. Strategic planning. We usually in the history have had a whole day of strategic planning. The comment I'm going to make right now is that we are very underwater with what we already have on the board.
Since
Maybe
I've
we
been on the
push-
Board, we've never had a strategic planning
Oh.
session other than in the
I think
fall.
we did it two years
Yeah,
ago.
we did 2 years ago.
Okay,
Yeah.
yeah, I mean, we
Yeah.
did
But
when
I
I
don't
was on the
think we-
board before.
I I don't think we need it.
I think
yeah.
if anything, we do it in the fall when the management contract has been decided and we have a further direction on where we're going. So yeah, I think we should, my opinion is to table that.
You want to take a vote on that?
You want to vote on it?
I think that's an outstanding. I think we should have a strategic plan in the fall when our needs resolved.
For what it's worth, I actually do have a couple ideas with respect to strategic planning, but I also agree. I think that's better just to lay dormant until our board makes a decision on the future of the management
Right. Because there's,
aspect. Yeah.
I,
You can't, it's not reasonable to anticipate if there's going to be any change, even to 1%, that would be executable with, if there's a change.
right,
So,
there's enough
right.
other topics going on.
So I would move to postpone strategic planning until fall of 2021, when a management company has been selected.
Okay.
Second.
Okay, all in favor?
Aye.
Aye. Okay. All right, so fall, we're gonna put that, I'll put them, make a note of that
So
for
set date was
September.
the next item.
Yeah, so-
Set the date. Well,
Fall.
hey, we just,
Fall.
fall.
That's a quick one.
But, so fall of 2021, so, okay. Board operations and communications. I guess that's more of a discussion than an action item. I know we had talked before in the past of the board being one voice and that we all, what we all decide on together is what we talk about and that we all stick to, so we're not giving different opinions or different direction to the community. I think that's all still valid. The role of the board is really the leadership and to listen to the residents as much as we can and get feedback and communication to the residents. Management activities, I think in directing the management team right now, we need to do it in a strategic way, which doesn't mean all 7 of us calling all 7 of them or whoever I think that's going to overwhelm the staff. I think in the one voice and the one direction will help keep CCMC sane as well as productive without running around. We don't want them chasing their tails after a whole bunch of stuff that everyone's asking. So I think if we need something from the board, or from this management team, we need to discuss it and then ask for it as a whole, and then we get our response back. Any comments or questions or additions to that? No?
I'd like to ask about the weekly updates for the board.
Yes.
What have you done in the past year? Have these been written? Have they been emails? How's that been done?
Just, they're sending them out to us as an email document, as an email update. You've been sending them on Friday, towards the end of the week.
Correct. It is, I think for the benefit of the newer directors, but this was something that our corporate management felt they wanted to start doing, but it wasn't Celebration specific. They're just trying to get a continuity with the same report across the entire company. So when you guys get into that a little bit more, you'll just need to tell us if it's useful, beneficial, if it's overkill, if it's double, triple handling, and then we either modify to what you need or we get rid of the redundancy if that's how you feel about it.
Most of what I see on which I assume you're going to send one out today.
Correct.
Most of what I see on there is just, it's redundant from what we've already seen for the week, or we already know. There's like no new information, which I guess is good because that means that we know what's going on. Or it can be bad that there is no updated information. Let's try it for what they're doing right now. They're sending out the update on Friday and then get feedback to them and to me if you feel like there's something that we're missing or something that is not needed that's on there.
So a couple of thoughts. Those started maybe 5-6 weeks ago,
Yeah.
ballpark,
Correct.
and they're only to the board. So it's not a community update.
No.
And frankly, I don't learn anything reading them because we've been talking and we've been meeting, and if it's helpful, I mean, you haven't seen them before until today.
Yeah, I'm not really interested in you wasting time.
Yeah.
If it's things we already know,
that's what it is.
redundant information, you just talked about being kind of burned out by the end of the week. That
Mhm.
kind of template communication is generally not very useful. All things considered, given the amount of major issues that we're going to be facing, particularly in the next couple of months, I'd rather cut down on the amount of reading and work that we have to do. So if there's nothing new to report, the board books historically have had all the metrics. right? I mean, they continue to
The
do that.
monthly- The
Yeah.
monthly board book.
Yeah, and I don't know, if I want to find the metrics, I guess I can find them. I really don't feel like I need a management report telling me that again. And it doesn't seem like it's the most useful use of your time or your staff's time. So
I agree.
Let me ask the question a different way. What type of report is useful for you? The reason, the genesis of my question is I always found the best reports were the ones that somebody actually was using themselves. You know, if you're doing something just for us, that's just, it's never fun. It just creates work. Is there something that you do for yourself or your team that is of value?
No.
I think that what you're asking is different. So we produce the book, workbook, or like you said, it has so much of this work. And then it has made, it has, action items, so it gives you in the management report. So if you're looking for like a weekly update, you're looking for something that's smaller that's happening in the board. Is that what you're saying?
yeah, I guess what I'd like to know is if Diana and Neil have met and there's something that's like, we've just made a decision, or we just found out something about the engineer, or
Right.
that kind of communication is what I would like to see. But I remember the reports we got a few years ago, and they went into the junk mail folder. I mean, they just
Yeah.
didn't add anything. Huh?
Including the ones I wrote?
No, yours were brilliant, brilliant, always brilliant.
For me, Brian, I'll try to answer this, and I'll try not to be, I don't know, unprofessional, but the reports that are important to me that the board should have are the board packets each month, meeting minutes, and the financials. That to me is the most critical. Now, to be fair, and I'm saying this not to placate you, but if this happened to be a board on a community that was relatively new or maybe small, you would love the report, like the template of the report that's being sent. Because Celebration is light years ahead of most other associations, aka corporations, it does feel a little redundant because the communication here, even though we still have room to improve, we overshare and we over volunteer so much information. I think by the time you get your weekly report, you're like, yeah, I know what we did this week. And like, for example, like my thing that I had to send this week, we had the election, we had the annual meeting, we have this, and there was something else in there, but you know that because you were all part of it. Anyway, I think if you, yeah, Diana, maybe we just look at it for a couple weeks, you tell us, but I don't want a situation happening where Jackson, like I do the same thing with other things I'm involved with. I don't want to miss something because now I'm in the habit of just sending it to trash because it's not been
Well,
useful.
and I think maybe we need to see, because there was a couple of things that you put in there that I didn't know. There was a couple staffing changes or where you, an update on where you were on hiring or offering a position. That's another thing I hadn't heard before, but I knew about the election and I knew about.
Yeah, that's a me thing.
So,
I want to be
why don't-
transparent.
Why don't we try it?
How about updates on what's going on with CCMC?
Right, that's what it's from. It's,
Right.
yeah, it's the CCMC update.
Just from them, not from what we've already discussed.
Right,
Because,
just
we
things that
already
we
know.
already don't know. Yes,
And forgive me for going back many years, but
no, but
that's what I know.
experience.
So after each board meeting, I was going to the minutes. Always there was, can you follow up on this? Can you get so-and-so to follow up on this? Can you get this information for me, blah, 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 blah. And when I got to my desk in the morning, I would send out an email to everybody who was mentioned there, Jerome, who was the office guy, the board has asked you to get, follow up on this. And then, it was on them to follow up. I think I would appreciate that all those little tag things that we did during the meeting, to be put someplace, just bullet. And then as Susanna found out the answers, this issue resolved, do you want it on the next workshop or, just something like that. So we can keep track of everything that's just kind of dangling out there and we don't lose track of things until like, it's like, hey, didn't we ask for, and I've never worked with you folks, so I don't know if this is an issue. But I know in the past it's been, didn't we ask for this like 2 months ago? Where is it? And sometimes you gotta like, oh yeah, and another note.
So you just explained much more eloquently why to me meeting minutes are more critical, because our meeting minutes should be defining what directives that the board have requested of management, and we should be doing our minutes timely and then following up on that so that by the next meeting, when you're approving the meeting minutes from the past month or whatever.
Those kinds of things weren't included. They were just kind of like sidebars, you know.
They're not in the minutes right now. It would be a good addition.
If it's, let me correct, if it's a conversation, it won't be in the meeting minutes. If it's a vote and
Like conversations, maybe the board was working on a longer term project. And in order to make a decision, they wanted this piece of information. Can you get that for us?
What part? What we're moving in.
And not part of the minutes, just little notes like.
Items after you kind of act on it.
Yeah.
Something different.
Yeah.
Follow up.
Yeah, exactly. Follow up on.
Well,
Mhm.
I think, so for example, where I've just asked you about the engineers reports for the, this next meeting. I would like to see that somewhere, either as a sidebar or part of the minutes that says this is a request that was made.
Mhm.
Now, if I have to take that to a vote to get that included, then we need to know that so we can take the vote and get it included. I'm not sure what, as president, you decide what you want to do with that, but somehow that needs to be communicated so it's clear to management that that's something that the board as a whole wants to do and not just something an individual board member.
Mhm.
You know.
I like that, a running list of outstanding
And what
items, that-
resolved will be part of the,
yeah, action items. that-
April, board packet, blah, 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 blah.
So
Um,
one of the thoughts, I don't know, I'm hoping that Microsoft Teams will allow this so that there's some tracking online that we can all go to. Because with the current email system, it's like, have I done those minutes yet? Or what do I have left that I need to do? So there's some tracking there. There's some, it's various to-dos and we can see who needs to do what. And if there's something master that's posted that
Or
we
if
can,
there's something that we think is taking longer.
or
than
there's
it
something
should,
that-
So-
I'm not the
that
tech guy,
Susanna
right?
was
Why
gonna
it's
do
held
and
up.
she was asked to on March 5th. What's the
Yeah.
status of that?
So really what you're saying is we need an action, we need a due date, and then we need an update as to what's going on with it.
And then the
And that-
parallel to that is I see this with committees. Because of the frustration I've heard from multiple committees is we meet again this month and we're doing the same thing we did last month. And the homework, quote unquote, homework assignments by whomever, committee members, staff members, wherever, wasn't done. So clearly defined action items. Here's what the dog cart committee, recreation committee, whatever, has decided. Covenants and ARC are so different.
Yeah.
Exclude that. But here's what was decided. Here's who's going to do it. And the next meeting, it's like, why is it not done?
Mhm.
It's like a to-do
I mean,
list.
it's like a to-do list.
Well, and
You
that
check it
really-
off.
That really-
Their own minutes, have changed format recently.
Yeah.
So they're starting to look at their minutes.
We need to
Then I
look at
wrote
that.
out and approved them. I think that helps because everything's on the same page.
Exactly.
Written it down, it's great.
Exactly.
I know I always appreciate it when our communicate on the meeting minutes. I was in the recording and I may not hear it right or hear different things. I will say that what we started doing in the offices with our department heads is after every workshop or board meeting, we all meet together.
Yeah.
And we talk about.
They do what
it
you said.
is that we understood from the board was our next action item. And we talk about it and assign it and give a timeline and do it that way. So that we're clear. But I understand what you are saying and we support a.
Well, and then if you would share it with us, then we can look at it and say,
Yeah.
well, wait a minute,
We talked about your Friday
Yeah.
report earlier. I'd find it more valuable just to get, here's the list of action items. and-
Yes, exactly.
Well, and-
So if you
Exactly.
make it clear, that's the CCNC thing that they just started and he will give us his favorite thing. Because obviously we're in such good communication here
Yeah.
with the board of management that was presented for you. So that's, thank you for the feedback and
Okay.
then I have a better perspective now
Okay.
sort of pending items.
like I
Yeah.
said, when you do that meeting, the initial thing would be, this is what we heard from you this month. We need to, you want answers on this, and that's assigned to Patrick and blah, 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 blah.
Right, and then we can
And
respond.
ETA kind of a thing, and then we look at it and say, well, wait a minute, I remember that Diana asked for this. and then, during the course of the month and between the meetings, got it.
Okay.
And
And
then
I think to Kevin's point, that's something different than the meeting minutes. And the meeting minutes are just, here's what we voted on, here's what we approved.
It's action item. I
Well, that
mean,
would be the
that's-
value
It is
item.
act- it is
That's the
action
official,
items.
that's the official record.
Yeah.
And
Isn't that
then
what-
come
isn't that what we did?
Come April, when we do the committee meeting,
Mhm.
we inform them
Yes.
that this
This
has
is-
to be done.
Yes.
This is what we're.
And where
looking
things
for.
are gonna get stored.
Right.
Right, because they'll all be moving on to teams as well. Okay.
And another thing, since we're talking about committees, I flipped through here because there's the last directives for the committees. The ones that we used to do had, again, I apologize, had timeframes.
Mhm.
Like
Yeah.
just within the first quarter, will you please investigate
Yeah.
blah, 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 blah. within the
Okay.
first
It's an
quarter.
action item.
Yeah, I think that gives them something.
Exactly.
target.
You have to have something that's being measured, and, like you said, a lot of those committees, and I know, because I was on one of the committees for a while after I retired, and I got off because it
Nothing
was
happened.
just round and around and around and around the same stuff. all the
Every
time.
month,
So
the
I
same
think
kind of
they need-
discussion.
I mean,
Mhm.
the board is supposed to drive their efforts, so I think we need to just put a little bit of thought behind what it is we want to see
Yeah.
from this
From them.
committee
Okay.
during the course of the year, and we'd like to see it, and then follow up on it.
So it-
That's right, and clarity is very good, because we're here to, serve the board, so if you give us very clear instructions, what answer we're looking for questions, then we tell you what we're going to do.
So-
In your report, he and I are reaching out to everybody, but someone's out of town, someone hasn't been around,
So on the committee resolutions, we probably want to see those before the April meeting, then we can say, these are where we want to edit them, to give them specific goals for 2021, 22, whatever the season is. Okay.
And maybe,
that'll be the first thing on my pending item list.
Okay.
but I mean, maybe the process starts with asking them kind of what they have in mind for this
Right.
year.
Which
And
she
then we
said,
look at it and say, maybe instead of this, they should be looking at this.
Yeah.
Sooner rather than later, and then incorporate that into these resolutions. So everybody's clear on who's supposed to be doing what and. within
so
the-
they have a clear stated agenda that's to move forward on. Okay. All right. The next comment was the board book contents, what is helpful, what is not. Some of you have not even seen the board book yet, so I don't know that you can actually answer that. So I think that's kind of a pending topic that as you see things that you feel like you need or you don't need in the book, then we can give feedback to management on that.
They
Oh,
are
is this the
online.
book?
Yeah,
The-
they-
The monthly board book.
This
which
is the-
online.
This is the book that you'll get.
That's just information.
This is,
General
Celia,
information.
this is the book that you'll get a week, 10 days before the meeting.
A real book?
It's online and
online.
it will tell you, I don't know how
Online.
many pages
No,
it
we're
is.
getting real books.
Oh, you're getting it printed. That's fine.
Okay.
You can do it either way.
Okay.
But that's the book that you will use to prepare for the actual board meeting. That'll tell you what we're going to vote on, give you the backgrounds, the contracts, everything you need to know.
Okay.
And then
And it
that's,
will be about that.
That's
yeah,
okay.
it's not skinny. And I do it online, so.
And let me say, it is that big though, if you were to print it
Yeah,
out.
no.
It's like 300 pages.
And
I'm not
so,
printing.
It'll be interesting to as we evolve to see what to do to it. I've gone through a lot of redundant, so, the smaller we can make that, and more concise.
We have been down this project several times. I actually think the book is very good right now.
You think the book is
I would
what?
strongly,
It's
I think the
good.
book is very good because we've done the exercises like she just described. The issue you've got to do, and the reason I would recommend is you start thinking about it online, is you can probably print 30 pages, which is what I do, and then you can go do homework off of other stuff. Because if you're sitting there with 300 pages, you find out that 100 of them are the financial statements for all the different companies and stuff like that, all you're doing is killing paper and confusing yourself.
And the way they have it set up online, it's easy to click.
And
from
the
one
links, I
page,
mean,
the
yes, I
links
mean,
all
so-
work.
I would,
Yeah.
don't write it off quite yet. Save your books that you get in paper. It saves a lot of labor. It saves a lot of material. It's a great use. I promise it's the way of the future. It's the way we need to be.
Okay.
We can sit down and we can. sit
Yeah, I mean,
down and look and-
I literally only print, I print the action page and I make questions that I want to make sure I raise or something like that.
Then
It's
we'll
pretty,
go-
it flows really
Yeah.
smoothly.
If there's bids on a contract, you'll have all 3 contract proposals. They might each be 10 pages. you know, like a roofing. I mean, do you really want to go through that?
No, I've seen,
Yeah.
I've seen.
So I think once we
Sometimes
get
it's
through our
raining,
first couple
sometimes they
meetings, we
go
can circle back. Yeah, you've also, you've seen the board book many times, so, okay,
There's
so
one
this-
other
Okay.
Weekly update
yes.
that happens, or not, shouldn't say weekly, every other week. We've had for COVID, we'd had the briefing from Nikki.
Mhm.
I think the last couple of briefings have said no issues. I would make a proposal that we no longer get those briefings. If-
On Parks and Rec.
And the reason being is why have them go through that exercise, but should there be an issue, they raise it. In other words, to say the playgrounds are fine this week, the pools are fine, this basketball court is fine, this is fine, the last month or month and a half has basically been no issues. And I should say, and most of the issues have been no issues over the last 4 months.
Yeah, I thought everything's calmed down.
Just because you brought that up, somebody brought it up to me a couple days ago, and I didn't have the answer. Are we still doing hours in the morning at the pool?
One
We,
pool.
we modified it to one pool at the last.
We modified that at a
Last
workshop.
meeting.
Yeah,
A month
at-risk
ago?
hours at one
I think
pool,
it's Spring Park, isn't it?
I thought.
I'm not sure which one is, but the
Yeah.
answer is yes on one pool.
There is just a lot of bickering and fighting that's been going on.
No
That
kidding.
pool. Crazy, I know, of certain crowds yelling now at children and kids and all. I think we need to revisit that. I think truly, anybody that's at risk now has had the ability to go get the vaccine. Teachers have been able to get the vaccine. I think we need to start backing that up. Just as a.
I think that's why we modified it to one
Yeah.
pool and
But
certain
I think
hours.
at this point, maybe in the next month or so.
If you can get me the details of that, we can see.
If we could go back to the board books
Yes.
tangentially, the board book we got today, the 2021 CROA board briefing, as an action item, I'd like to get the current charter and the current bylaws.
And this,
Yeah.
all right.
Right, right.
Yeah,
But
shoot.
I'd like to get it on the I'd like to get it on the
If
action
you
item.
you started your action items, that's a good start. That's a good start for that. Okay.
Okay.
All right, email and meeting protocol. We all need to get our new email set up. That's the first thing on email.
Is that the one Patrick sent us?
Yeah.
Okay, 45 minutes, but I did it.
You did it. Good job. I haven't done it yet,
And
so you're
crying.
ahead of me.
Now remember, that email has to stay confidential.
Right.
We don't share that. Board meetings. We already really talked about that. One, just protocol during board meetings. We've done very well today. You guys have all been to meetings and we're not yelling or screaming or talking over one another. Just one thing that that's written on here, never cite a resident's name or address.
Right.
Just
In a public meeting.
in a public meeting. We don't want to shame anyone or bring something to someone's attention, especially when we're talking about delinquencies or liens, which we all are, that will be in the board book, which is the confidential part of the board book, which isn't published to the community. Yeah.
Email protocols, I mean, Kevin touched on it earlier. We all agree that's the protocol going forward?
So help me clarify what you just said 1 minute ago. Never share your email address. You're talking about the town hall one?
So in other words, the one we're gonna have that is town hall, that's not celebrate, at town hall.
Town
dot
hall.
celebration. You gotta just remember, that is,
So. if
this
I-
is
if I went-
confidential board business. That's what I'm trying to
Okay,
say.
so-
So,
Yeah, don't let other
So
people
we
log into
still,
it.
so I mean, I have several email accounts, so my Gmail account then stays. So if a resident says, how do I reach you? I
Right.
still give them my Gmail. I do not give them the town hall one.
No, all business should be at the town
new
hall
email.
But then
celebration.
why did you say it's confidential?
So in other words, you shouldn't be, so in other words, don't be giving, I shouldn't give Sandy access to my email accounts. In other words,
Oh, you're
this
talking
needs to be
about shared
confidential.
access.
I'm just stating the obvious. It should,
no, I have
Okay.
a question. I don't understand. So that email that Patrick sent us, if a resident, board business
for board
only,
business.
between the seven
Board
of us
business
and
only.
No,
management.
no.
A
So that could
resident-
be a resident
so
emailing you.
if-
It could be,
So if
Yeah.
a resident has an issue,
they're going to email you at that address.
yes.
so like I say,
That-
you know,
that's
if you
what I
have
wanted
an
to clarify.
issue,
Okay, so
email.
just to be perfectly clear, all of us are gonna have our picture on the website, and it's gonna say Kevin Kirby, and it's gonna be kevin.kirby@townhall.celebration. FLUS or USFL, I can never remember that. And that's where all your business should be conducted. And what I'm really
So
saying
we're
is
not sharing our
that needs to be
password
yours.
with
So,
anyone.
you know, I know you got like a Bill McFadden one right now. Bill needs to have his own email and
I
this is
can't
your
figure
email.
out how to do that. It's so hard to take his name off.
Well, no, you can let him have that one. This one is going to be your
Sure.
town hall email.
Yeah.
So
So
let me just thinking on that then. So I get an email to my personal email address that has to do something with board business.
Mhm.
What I should do is copy the body of that email that came to Cindy Swisher at Yahoo
Forward it to your
and
new
then
one.
put it into
yeah,
this
And just
one
re-
and send it from there so that from that
Yes.
point.
Or
on,
what I will do, because I still have my Brian at Gmail, I will actually respond to the person. I'll copy my new address and I'll say it should be going there. That way it gets there, but people get used to, this is where you gotta go.
And
this
this
is
is
where you gotta go.
You've been through this before because you had an AOL and then a Gmail and you transitioned everybody.
And given a little bit of time, I got nothing at AOL. The Gmail is already starting to stop, except I couldn't get Mr. Anderson to convert over. There was the biggest problem right down there.
No, I
But so
can't- I
so
couldn't
now,
convert
and you
till
were
today.
waiting for this meeting, so
I
I'm
couldn't
kidding.
convert till today.
And
Okay.
so everything converts and that way we're private, because you had talked earlier about the rule, which the rule we had, which we need to say we're gonna keep to or not, is that we would copy everybody on everything, so people were private. You can say, I care about this or don't care about this. And
So we're all on the
Right.
same
So-
page.
So anything that I get from any resident when I respond should copy all you
Right.
guys.
Yes.
So we're all on the same page and we know what's going on, no
Okay,
surprises.
well, but I wouldn't have thought of that unless he said it.
I think that, I think there's very few exceptions when you would not copy the whole board, because then we all know what's going on, no one's caught off guard, and, you respond.
get-
You
it's
may
be-
even forward to us and say, this is how I'm going to respond to this.
it kind of gets to what Jackson was talking about from when we were talking with Neil before. It's been try to copy everybody on everything so people just know, okay, here's the issue. So if you're really keeping up to speed, I mean, there's more emails, it drives management crazy, but that's why they get the big bucks, because they get copied on lots of stuff, 99% of the time. Whenever you copy Suzanne and Neil or anybody from town hall, it is on their database and it is a public thing. If it's a private amongst us only, it is a private email amongst this board and is not accessible in a Morgan & Morgan lawsuit or something like that. So that when you copy management, make sure you really want it to be a public
That you
document.
want them to be
Oh,
copied.
yeah, if there's a good reason. Okay.
That falls in line with your one voice, you're talking about Diane, so you have, especially if there's a topic that needs a lot of discussion, talk about it, decide what you're thinking. And then, we can start the feedback.
Well, the problem really becomes if you say you're never going to copy management and you're going to have one voice, whoever the president is, has got an impossible job. They'd have to decipher. I mean, you can get 20, 30, 40 emails a day sometimes. If every one of those had to be ciphered and forwarded by the president, it'd be a 16-hour-a-day job. So you literally, we put these communication protocols in place so that communication happens fast.
So if a resident sends one of us an email, it's agreed that we send
Send
it to
Respond to
everyone
everyone,
else.
yeah.
Okay. Do we have to send it to management?
And you
or
use
just-
common sense. If
Okay.
you say, Celia, you're doing a great job, love what you're doing for the board, you say, thank you.
Right, I
You know,
understand.
and if they say, I've really got a business issue, you copy everybody.
Right,
Um,
okay.
Yes, exactly. Common sense comes into there. It's okay. All right. So Beth, go ahead.
There are times, if I was dealing with Kevin, Kevin, I just need a signature or something. He doesn't necessarily need to reply to me and include everything.
That falls into common sense.
Yeah,
I think it's a common sense, it's a
Absolutely.
common
Okay.
sense.
Right, or if I'm dealing with a technology
Right.
issue, hey, Brian, just to let you know, I did speak with this person. He's gonna reply to me. Thank you, Patrick. See you.
It's a common sense.
Those are the common sense things that don't necessarily.
Especially with the point person and the liaison.
Yeah, exactly.
So that's
Point person.
that's the reason for that.
Okay.
I think that's something we could revisit if we get down the line and we find,
Yeah.
oh my God, we're getting 100 emails because we're copying on every thank you. Let's just be common. sense.
Yeah, common
Okay.
sense, and if something comes out you don't think is right, we need to just, address it to the person and move on. Okay. I think we've hit all those topics. The one thing we need to get working on is the meeting schedule, because
Yeah.
that's gonna be a point, and we're already at 2:20.
Well, And it could, while you were on your phone call, we agreed one more time, communication is gonna have to be early in April. Capital improvements, Neil gave a briefing. They're actually getting ready to put something out today that's gonna talk about all the different engineering reports and all the updates there. We said when we got to the meeting schedule that we'd probably need an hour where we just go to capital improvements. And on the business plan, we said we're gonna scrap the strategy planning day until the fall, until the decision is made with the RFP company, and then we should have a new meeting to talk about strategy for the new year.
Okay. All right, so meeting schedule. We have our monthly meeting. We don't have one scheduled normally for the month of March. But then we normally have it, and it's what, the third or fourth Wednesday of every month, except for, I think we skipped December. didn't we?
I mean, we look at the
Yeah.
Thanksgiving.
We look at the calendar.
Yeah,
Things like
however it ends
Thanksgiving,
up
Christmas,
in the
and-
holiday month. I say,
I'd say
I
we
don't
keep
see
it
any reason why to change that. I don't see any reason why we need to change that.
Consistent with the
So it's
residents.
the fourth Wednesday of every
The
month.
fourth Wednesday.
Fourth Wednesday.
And then I would just as soon they send out invitations, and then when you look at November and December, go right before Thanksgiving and right before Christmas.
Yes.
You know,
Just
a
make a
week before,
judgment.
something like that, like we normally do.
And I would, yeah, if we can get those invitations out, because everyone's planning their year.
But can I also say that we need to be cognizant
Well, because we've already got the 15th, the 22nd, 29th, and we're gonna have to add capital improvements. So, no, we're gonna have 4.
Make sure that
Jackson.
That we're not on,
Not bored?
on a high holiday. Okay.
So it's the
So-
last Wednesday of every month?
Fourth,
or the
fourth.
Fourth Wednesday.
Fourth
Fourth
Wednesday.
Wednesday.
Fourth Wednesday.
And,
of every
and,
month.
and
Okay.
invitations will come out.
Okay.
So you'll get invitations. I think we still need to continue to do Zoom and in person. I do think I think we could do in person in this room for board meetings, for those who are comfortable with that, but we also still need to have the Zoom option.
But then do we-
I would like to ask that we not allow visitors in this room.
I
The-
agree with that. because
I mean, this is manageable for management and us. I would be personally very uncomfortable if we opened that up and brought
And I agree.
individuals in.
We
I
have
would too.
2 people in the audience, minus me now, so there would only be 1 person.
Yeah, it'd be you and Gary Hudspeth, but you know,
And
maybe Mike Jackson.
occasionally.
I think I love this setup, and I think we keep the public virtual, and
For a while.
we've done a very good job at allowing them to ask lots of questions. We
Yeah,
just
and
be
they-
very,
Again, they can speak at
professional
the
in how we-
beginning of every board meeting. We still maintain the resident comments, and but we all maintain. If
And
you
I gotta
just
say,
maintain
I
it-
like the horseshoe. I like being, I mean, I know Kevin's not thrilled seeing me, but you know, I like being able to be there. But I can hear better and I can see you. It's a better layout than what we used to have where we were stretched.
well, and it
out.
also works
So-
now, if you're on the road, like some of us are, you can join the meeting and it happens. I mean, it gives a lot of flexibility. This is,
It does.
So
The only
if,
thing I'll say is when I've heard it, like TV, maybe you can, we'll give it habit sometimes, but the microphone, like speaking in his microphone, I've heard the TV computer, and sometimes if you start to turn and talk and.
well, if you get somebody like Gary Moyer who talks like this, and you never hear.
All right, David?
what I would ask us to do, I agree with what Jackson just said. You know, this arrangement, usins only. And I don't know how you spell that. Usins. Yuns is Northern
Yuns.
Ohio. When I don't know if anyone else had a hard time sometimes with Tom speaking, and it's probably coming from a speaker to the back of that TV.
Yeah.
So I would look at the sound system so that it's crystal clear for us, or like when a resident speaks, and then make sure that we are, this is a Patrick thing, and then make sure that we are, and that, I just said that sometimes Tom was hard for me to understand. Was that me or was that anyone else?
No, it's me too.
At the beginning, he was talking very fast.
Mhm.
I
But
could
But
understand.
it's,
you
there's a
fine.
sound
Oh,
issue. It's
I
a,
think we need.
I think
a
the speaker's
better-
going that way.
We need a better Zoom microphone
The whole
system.
packet. We need to
And
look
this
at
is
the
not
packet.
gonna go away, and I know we're going to Teams, so we need to investigate something that works better for Teams. If Patrick,
The hybrid.
the hybrid with
Yeah.
the team set up, and if Patrick can, I don't know what's available, but I think we're gonna have to end up making an investment in something.
Look
to
at
make- because It's
options.
not gonna go away.
Look at options, price them out for us, just so that we
That
can
goes
hear
on the
well
to-do
and that we are, and that we're doing well to the residents. Is this the best camera setup? I mean, those sorts of questions.
Yes.
Just I would say just go for it, and then we have to decide if that's
I
what we
can't
want to
imagine
spend.
it's gonna be
Find
that
out what
expensive.
Corpus Christi uses a church, their feed and microphone and all of that works well on
So
Sunday.
they've got big old soundboard and all that kind of stuff.
Oh,
Figure it
There's
out.
speakers in the
Yeah,
Oh,
that's,
okay.
you're,
Patrick's good.
Patrick
He's
knows
got
what to do.
backup, so.
okay. Okay, so the other meetings that we already have, the 15th, the 22nd, and the 29th for the RFP, which I'll fill you guys in on that. The one that's been weighing on my mind, we have not had a covenants finding hearing review in a long time.
You mean
Appeals board?
Appeals, I'm sorry, appeals.
Oh, and appeal.
Yeah.
I think we have it in a couple months.
I thought
Okay.
we had one in February, didn't we?
Did we have,
Yeah.
did we? Okay.
I thought we had January
Maybe I.
and we didn't
maybe I
have
missed one,
February.
but still.
One time and then
Okay, that's just weighing on my mind. Do we need to get that onto the
Should we
schedule?
generally schedule one for the whatever?
she would like one this month, actually, because we didn't have it last month.
That's why I thought we had.
If you want to rather than making a call out for that, and for the new members, we have to have 4 present. So it doesn't mean all 7.
Explain the silly one.
So it's an appeal, someone appealing the covenant's fine. I got fined
Right.
$10,000.
I called you the other day.
Or
Oh, yeah,
I'm
right.
appealing what ARC didn't let me,
They didn't let me
build my 3-story addition,
Or the
Or fines
military
or whatever.
vehicle down.
or a fine, yeah.
Yeah.
So do we
Oh, yeah.
want a regular time every month that's
We
on the
do-
books,
we-
and we cancel it if needed? I mean, if,
Out there when it comes up. Because otherwise we're gonna waste a million hours just figuring out different dates and that's gonna happen.
I mean, do you want it the second Tuesday of every month? I mean, that's just, I don't know.
When they come out, they come out.
Then we see who can
Why
go.
don't you ask the committee what day would work for them?
Well, they don't
They don't
come.
come.
They don't
It's
come.
irrelevant.
We are the committee in that
They're-
case.
No,
No, no,
no,
It's
just us.
no.
Just us.
Just us and the resident.
What I did was like the second Tuesday of the month or the first Tuesday, we can put a schedule on, send it to you. If you're okay with that, and then what happens is we just check every month.
And do you,
Is
and you
it
need to
90
have it?
days?
I assume every month we do.
And I mean,
Okay.
it's important. Sometimes we can skip one.
Okay.
Just
Let-
book
let
them,
the
book them for
schedule-
all year and have us respond accepting so that we can get them on calendars.
And you needed something for this month. So-
Okay. Mhm. Send it out.
Send it
Have her
out.
Send it out and let's get it on there. I'm sure it's 4 of us in the room can do it. Okay.
Did you talk about your first workshop? yet?
No, that's the next topic. I know Neil says Fridays are bad, but
Fridays are
I
good.
work Monday through Thursday.
Fridays
I
are
work-
good.
Fridays are good for me. Are Fridays a problem for anyone else? I'm sorry, Neil, he's not in the room,
Oh, no,
and I'm
that's
sorry,
okay.
Sue. We've been doing them Friday at 10 o'clock in the morning. They usually last between 1 hour and 2 hours. You guys have been on them, you know what we do. And we have a running list of topics, and we'll just pick a couple of topics for each workshop to workshop that week. And then if something else comes up that we have to do. So looking at, let me pull my
Before
calendar.
you go forward, I would propose we go back to where we were with workshops 3 years ago and have one workshop a month. And
We
make
went
it
to
two,
the
make
every
it
other
2
week.
hours.
We went to every other week on COVID.
Yes.
We went to, started with every week on
We
COVID.
did, yeah.
And
you're
then
right.
maybe 2 months into it, went into every other week.
Yeah.
We already are overloaded with RFP stuff. I am just, we're gonna end up with 8 scheduled meetings a month.
At this point.
So I would just argue for one workshop, have it 2 hours, not 90 minutes. Maybe we have 2 topics, not try to accomplish the world. We have 2 major topics that have already come up today, communications and capital improvements. So I'm just putting that out there, rather than try to overschedule ourselves.
Any other comments?
What if we maybe move the time up to 9 instead of 10? If we're gonna go down to one meeting, and if we can accomplish whatever in an hour and a half or 2, and that's your goal.
Would that have anything to do with
Yeah.
Rummy Cube?
Yeah, that's
Maybe.
it.
Is that
Well,
a
then
Friday?
I vote yes,
Is that
Is that a
because I'll
Friday?
be.
Is that a Friday
Okay.
thing?
But no,
Wednesday and
seriously,
Friday.
I mean, if one little item comes up that might be discussed, we can just tack it on there and not have to schedule another meeting to talk about this. little thing
I am-
and whatever else.
I mean, I'm up at 4:30 every morning. I start work at 4:30 Sunday through Thursday, so I'm awake. So 9 o'clock's fine with me.
I'm fine with that.
So I'm fine with that.
What
So
about
if we
those
look-
of us who work?
I'm sorry. Yeah.
So I'm like.
Oh, God, I'd be, where's your second monster? You need another one. Okay.
Was
so
that
if
work
we-
or play?
If we do, are we gonna have a March?
Meeting in the middle of the night when I'm up, like.
Oh my God, we're all on
Oh,
different
you're
schedules. This is
gonna
gonna be
invite us all in
fun.
the middle of the night when you can't sleep? Hey, folks, I'm up. Can we get a quorum?
Oh my gosh. Okay, so do we have enough need a March board meeting? And I think we already decided, no, we don't need a March board meeting.
We do not.
But
thought-
so
We
then,
need a workshop.
I thought the only thing we were talking about for March was just a workshop to talk about the capital improvement.
so
maybe one
Fridays,
workshop.
so either the 19th or the 26th.
Yeah.
Would be the days.
Both are good for me.
So we already.
We're talking about
have
9 o'clock?
Yeah.
Is that what, or 6? Or
9 o'clock Friday morning.
9 to 11?
It's, won't go that long, but yeah.
It won't
so
go
let's
that
book,
long.
let's
If-
book it.
Book it to 9 for 11.
But are you, no, you're not back. Are you not back? 19th?
No, but I mean, I can come in. I mean,
What's the
when I'm
time?
coming in, I mean, I can zoom in, but
Let's do it on the 19th because I don't want the capital, the field issue to go any longer. than
I
that.
agree.
Okay, and then, yes, and then go ahead and let's kind of stay with that process, which is, what is that, the third Friday? And book them the third Friday of every month.
That's the week right before the board meeting.
Yeah.
so that gives you 2 weeks and to avoid
Let's
getting,
just do March.
Yeah,
to avoid getting slaughtered, we're gonna need to get a good document out and back to the 19th, because if we don't, we're gonna get killed.
on the field. That's what
Yeah, we've got one topic for the 19th. Let's get through the 19th. You know,
okay.
Let's just do one. And
You want to do you guys want to just do the March 19th and then we'll see what we need to book out?
So you had two topics, but you had communications too. You want, is that workshop just for the capital improvement?
I think that needs to be the priority.
I think that's the top priority.
Yeah,
but I think April ought to be communications in.
That's fine.
I
We can
agree.
set it whenever you guys are ready.
I
that's
agree.
fine.
Can I ask a question about an issue that's going on, maybe added to a workshop?
Okay.
and moving forward? There's an issue that's going on down at Lakeside Pool at night. It only came to my attention during Food Truck Friday, so I don't know if it's an ongoing issue.
Security issue?
We went and sat in the pool area, a couple of residents and I, and there was like, JR actually knows about it, and I think, no, I don't think. Nikki was
What's the
here.
issue?
Yeah, what was
There
going
was about 15 kids, maybe 15 years old. They were using the handicap seat, pumping it up. They were flinging each other in the water. They had their clothes. I mean, what kids do. But,
Yep.
I mean, they're what kids do, but the chair could be fixed, but it was dangerous because they were picking each other up by the feet and the arms and flinging each
No.
other with their clothes on in the pool.
We do
And
have-
there's
it's a-
no
what's the se-
accountability if somebody gets hurt.
Didn't you tell them you were a CROA board member?
I had my shirt on. I had my shirt on and that said Celia for CROA. I said, I'm not going up to them. They're gonna go home and tell. But we came out and I spoke to JR and I think a couple of residents spoke to JR and he sent the monitor in. And whoever else does the lifestyle, I forgot her name. She went in and we finally, they finally
with
got
it.
them out of there, but you know, you can fix the seat, but I would hate to have a resident walk in one morning and find a kid laying like face down in the pool.
We do
Well,
have,
is,
the
is this something we could turn to management to?
yeah,
to
that's what
work
we
on?
need. Management
Yeah.
needs to be made aware of it and they need to make sure the pool monitor's there. And we still have security, right? The nighttime security
Yeah, but the
guy.
security doesn't go in the pool.
He should, yeah.
Because they left once the monitors came
Oh, yeah.
in and made them leave, but
course
there
they
was
did.
stuff floating in the
Okay.
pool. Okay.
Okay, so is there any other meetings that need to get on the agenda?
With our psychiatrist.
April,
Why don't, when do we want to do a communication meeting for April? Just
I think
set
we
that
should
one
just,
up.
you want to go ahead and just schedule it?
I
Just
mean,
get-
and then after we get through that one, we can look at the rest of the year. figure out
So
where
the,
we're
how about the 16th? April
Sure.
16th?
Sure.
Okay,
That's gonna be the workshop for communication.
yep.
at. Move it up a little, what Kevin said. which is fine with me.
We could do it on my birthday on the
But-
9th.
Is there, well, the week before is Good Friday. Is there a Jewish holiday that week?
No, but it's good.
Passover?
You want to move it up a week? We could do it on the 9th, as long as you don't mind. Easter's the 4th. So that's a month away. Is that too far?
April 9th?
Yeah.
Is it okay?
Okay, April 9th. So we have 2 workshops scheduled,
9 o'clock?
all the board meetings and all the RFP meetings, and we've got, they're gonna send out covenants, appeals hearing. Okay. March 15th from 6 to 7:30. It's gonna be the RFP task force and the board only. And it's gonna be in person and Zoom. The 22nd of March is going to be a public meeting. So it needs to be Zoomed. And we won't have residents in person, but the board can be here. And it's also a board and the task force if they want to attend. And then the 29th is a if needed meeting, the same time, these are all the same time, 6 to 7:30. A question and answer for residents on the RFP process.
Kathy, you were gonna send that email with the addresses?
The last
Okay,
two,
Okay.
the 22nd and the 29th. Yeah.
So this communication workshop is kind of like totally new. Who does the agenda for that? How do you arrive at the agenda for that?
Basically, yeah, you want to look at things out, you want to talk about what's that. Conduct that will be. Discuss what we mentioned about Facebook, social media, how do we get messages out there, what are.
So is it going to be a collaborative thing that we should all send our ideas on what we'd like to discuss about?
All those
I mean, who's
ideas.
going to do the agenda?
Will Hanson does it, but what happens is, we'll send it to Diana, the president, and then she'll maybe solicit feedback from y'all and then come back with some finalization. If they want to finalize and post it.
Okay.
But to Kevin's point, it is a workshop, more discussion and more free flowing, so there's not always an exact kind of line to follow.
Right. And we normally don't vote on things at the workshop unless it's something that has to be done at the workshop. We only vote on things.
But we
that-
should also, we should, communication, we've been talking today, so how do we think about the RFP? When do we do a public versus private meeting? How are we gonna communicate what we're doing? How are we gonna, there's a lot of things where things we take for granted, most people in the community don't get to except through the grapevine, which is why the porches are so successful. Are there better ways for us to communicate and all kinds of junk? We ought to have a outside the box conversation a little about what's a better way to structure it.
There should be processes to all this stuff. That you're talking about this and then it's talking about this.
David is positively quivering with excitement.
They're doing SOP.
Yeah, but okay, then you have to have priorities, because at some point in time, you have to say, everything can't be that management will take care of this and management will take care of this and management will take care of this and nothing gets done. And that, I'm not trying to be a jerk on that.
It's not it's like, that this particular thing, we need to make sure that it's in the private flash. We need to make sure that it's in the paper. Just.
Well, there may be core questions or core issues to address.
Yeah.
Like, how do you attend to residents who can't figure out a website or don't have a computer? How do you, let's think outside the box about communication. And there's a bunch of questions there. Huh?
Or won't give us an email address.
Yeah.
I'm not going to tell you, but
Okay.
you need to notify me.
Okay. I think the ones who haven't had teams set up, I'm gonna stay and try and get that set up. for
Yeah, I'm
me.
going to say,
It's
Yeah.
it's Outlook.
It's Outlook. Okay,
Yeah.
yeah. I need to set up that email in Outlook and get that,
did we set a communications date?
for a meeting, April 9th.
Oh, we did April
Yeah.
9th.
so I
Okay,
think
thank
we
you.
know, Yeah. Okay, and she's,
I'll be sending out a list of my preferred birthday gifts.
okay.
Outlook is so simple, even a man can do it. So you can
Don't
take care of it. I could conquer it in a half hour.
All right. All right. Are there any other topics that we need to cover today? I think we've exhausted everyone.
Just to be
Jackson?
clear, the standards of conduct
Mhm.
needs to reference the new
Yes.
bylaws.
yes,
And once we've
we-
got that, then I'd like to go back to this and.
We need to get that updated for the standards of conduct.
So we're not taking this with us.
it's, at this point, it's not a valid copy since it doesn't have the proper reference.
And they're not taking this.
Well, I'm just leaving the bylaws. I think
Take it.
just the
They'll just give you a
bylaws
new
are the only
section.
piece.
I'm
They'll
gonna
give you
take
a new
this.
section for
We'll
that.
just-
I'm gonna take it and she's gonna give us the next time we meet, or you're gonna get
I'm
us
gonna
the
leave the
updates.
bylaws here.
I would just ask you to go ahead and take what you have and I'll have it delivered to you.
But you don't want these
Ooh.
back for recycling?
Throw it in your-
The bad bylaws.
Sure, you can leave them.
Okay,
Yeah,
thank
but go ahead and take your books and I'll have everything delivered to you and it's still,
Okay.
Jackson, that's like an old
All right.
painting.
Any other issues?
So with the standards of conduct, other than that one item,
I'm fine.
are they okay?
Yeah, and then that would be updated. We didn't review it at all, so we probably need to review that. at our-
It's pretty much what we've had for the last 2 or 3 years.
Yeah.
I think Jack was the outlier 3 years ago and we argued over one bullet,
Mhm.
but otherwise it hasn't changed.
So can we say that we will look at this and review it before our April, because we'll do this at our April board meeting.
We can do it anywhere. We could do it in a board meeting, a regular
Yeah.
board meeting if we want, just to.
Yeah, so
sign
this
and
will,
approve it.
is it the last April board meeting?
yeah, so we'll approve it and put it on the April
Add it
board
to my
meeting.
list.
So a question about Microsoft Teams and what its capabilities are, is there an opportunity to be briefed on that? Or could that be a pre-workshop discussion or something? I look at you because,
Would
I
someone
mean,
from
I have
technology like to
dreams,
come
not
in?
not literally dreams.
Now that
I-
you,
I
now
have
that
thoughts
you are
about-
on the technology committee and I copied you, you can add this to the agenda. I think there's a meeting next week on Tuesday, which you can stand
And,
in for.
and
Because
then I could,
everyone's gonna, we've got to get it to the committees. because
yeah,
they
so
all have
it's
it.
it's just a matter of,
Your question is right, and I copied you on an email and
Okay.
Jim's responding, and I think it'd be great to
just
talk
to
about that.
Okay,
get briefed more on its capabilities. Because again, I've had some hopes about what we can do technologically that will help. I mean, in terms of what Microsoft Teams is allegedly going to do.
I think first thing we got to get everyone on there, right?
That reminds me, Susanna put in her things to do. I asked her for like everybody's phone numbers.
Yeah.
I don't have everybody's phone numbers of the board. And then in this book, is there a list of committee members? Who's on each committee? I would like to know that.
Well, those might change in April, so how about?
They're gonna change.
after we pass the resolution?
Do I have a question?
But I'll put those
Oh, no.
You have a question?
So I have my email set up. And Brian, I got an email. You have your email set up. So
Yeah, I
there's-
sent you an email because I saw you
Yeah,
had
you
yours set
said
up.
something about you'll be doing grass. So I still only have 3 emails in there. Should I have gotten more emails? I have no
Probably
idea.
not.
Well, everybody's making the conversion, but now that we're all gonna be doing that one, every time there's an email, it'll go to that address. So
Okay.
it's getting up to speed.
Okay.
And you've only received one email from me, and I just was sorry because I'm translating. I'm not gonna send any emails until you get your email signed, because I don't want your personal email getting
Yeah.
requested in the court as discovery down the road. So that's why you've not gotten one email.
Okay.
Did someone send a password out to set this up?
Is there a pass? you-
It's in the email.
New members have gotten their emails with a template password.
How about the old
I
members?
don't- Did you ever get an
The
email?
answer is yes, you got one.
I'm sure I probably did.
I don't remember getting one.
Follow up with Patrick.
Well, for you guys,
I'll
I
work
think
with-
mine's been there a
I'm gonna
while.
stay and work with Patrick.
That's they have a thing called new mail and really old mail, David.
Yeah, I'm thinking maybe I need to figure out.
Yes.
For my-
Oh, I love
All right,
Outlook.
any other questions before we adjourn? Yes, ma'am.
So I'm going to, I'm sure it sounds like you're working on your emails. I'm gonna assume you're all gonna have those set up by, say, Tuesday. And then Wednesday, I'll send the list that we talked about, pending item list to all of you and your.
And make sure that's what goes on the website, that it all gets updated, because people will want to start sending
Right.
emails. And I'm gonna tell Gary to send the package to the new email addresses, so.
Good.
Yeah, we have it, speaking of, do we have an ETA or when those minutes from October and forward are gonna be?
Posted? I think they're November's up.
Yeah, November and December are out, and then we just signed January. so-
When's it December?
Pardon me? There's only one in December, it's one workshop, but. And we just hired somebody. We think we did.
You hired someone? Good for you.
And then
Oh.
Trey-
Is there
Is there a way for us to approve board minutes quicker without having to go?
Yeah.
So in other words, it takes, my first problem is you sent minutes from February 1st, you know, and at the end of March, you're literally sitting here having to try to remember what the heck's going on. So I would love it if we could make it a little quicker. We've been going through a transition, so that's not a criticism. But is there any way we as a board can say, here are the minutes, even if we approve them as a formality to get them out there? Because we have had people say, I'm looking for minutes, and it just seems like we've always got this drag.
As long I have an answer. Well, hopefully, when you want, this one doesn't fail on us, because we're on number 3 right now. We can circulate them and just put a
Put a watermark.
watermark that says draft.
Draft.
behind it, and we can circulate it ahead of it.
So
And then we do
I'm
it-
talking
we do have
posting
to
for the
say
public
draft.
to see it.
It doesn't have to say draft. I mean, it's no different than audit. We circulate audit.
But there's a process. So they're crafted, then the board reviews, and then it could be published as draft.
Well, can't you do the approval on those via email
We
and
are.
then just at the board meeting confirm? Or what, there's not.
I think the
That's what
board,
we do
I think
now.
for them to become official, the board has to do that. My question would be, and this may be incorrect, but if we had the circulation, there's always 2 or 3 of us that comment, you know, and then we had like the final draft, which could watermark, and then I agree, we've got to go to the board meeting and do a final approval, but
That makes sense to
That
do
makes sense
that,
to me.
because then there's not the delay between the
but
approval
we have
and the
had,
next
we've
board
had
meeting, which could
members
be
of the
months.
public ask this question.
Mhm.
I mean, the good news is people are looking, the bad news is people are looking.
Right. Well, and I understand that you're looking, but, and Patrick can verify this. We had those board minutes posted the day after the board meeting, remember, Patrick? Because, yes, we did.
How did
Because
you-
I would have the copy,
But did the managers hadn't approved it yet, or
the secretary, the
board.
property managers,
The board didn't
and the
approve?
secretary approved that there was nothing missing and this is correct and blah, blah, blah.
So nobody else weighed in on it?
No, just the secretary and the management company, because they were keeping also their set of notes, and then I would also take notes. Right, but then, so then, the night of the board meeting, I would have those minutes for the secretary to sign right after the board approved them, and then the next morning. I
Yeah, but
come
that
in
would
and
be
I
a
would
month
give
in
them-
arrears.
So how many months are we?
Yeah.
So
And now
we're,
we've actually set it up, sorry, because now we have electronic signatures, so the second it comes out, they send me electronic signature, I sign it, posted the business. day.
Mhm.
So
so,
that part has been.
Mhm.
so what is
Before the board
posted now? October?
Well, that's what I'm saying, this got posted the day after, the morning.
Yeah,
after-
well, he's saying,
I don't think we can do that
but,
until the board
well, no,
looks at
but
it.
you said it was a month in arrears. It was the prior month's
Right,
minutes.
but that's what we're doing now. You can't post the current month on the day that you have the meeting. or the next
Well,
day.
no, that's, I think.
I like breaking up. We finalize the draft, with the, like Neil said, with the watermark, and then when the meeting comes, we ratify that. and then-
Okay.
So may,
You think is there a legal problem with posting them with the watermark?
Gonna ask the question.
We'll check with legal.
All right,
so maybe a timeline could be within 2 weeks after a meeting, it gets generated and approved by the board, updated by the board, and then posted with watermark, pending the board approval 2
So
weeks
you
later.
can't- I know there are some, there used to be some things that the board could approve via email and then just ratify it at the meeting. And you're saying that you cannot do that with the minutes?
What I'm saying is, I don't know what Florida state law is when you're referencing. I know from I did my. But for CAM, that the meeting minutes have to be ratified and approved at the next regularly scheduled board.
I think that's pretty
Why don't we
normal.
just give management directive to come back to us and tell us
But
what's
what I'm
needed?
saying is to combat that gap, which is what I think you're talking about, Cindy, is that within 24 to 48 business hours, if we circulate a draft of watermark draft, I'm not saying to approve it on email, I'm saying if there's any modification,
yeah,
we
edit.
can then just publish the pending draft, because we do the financials, those are always unaudited. So, and then we'll just make sure Tom, doesn't- I don't want to get you in trouble,
Okay.
but that's a.
Are you guys clear? Everyone's clear, right? That
I'll
the-
ask Tom, but
I got the message. And then I
Okay.
also just want to say, because I think sometimes they get detailed, legal has advised that this be very broad in general and not so specific. And I think I've seen them making the use of like the types of, they get a little more specific, but really, I think this was referring to this very broad kind of motions and discussion. May see that.
Can we encourage the same thing for committees? A quick turnaround with the committee minutes from the committee?
My opinions on committees are very unpopular, but I believe committees should be no different than board members and trainers. Thus, what you do, if it's good for you, it should be good for committee members. But that's not very popular.
Well, that's going to be brought up in the April.
I don't want you to get yelled at in the street.
Too late for that.
Yes, I will. I will by the end of the day.
That, you know, that point right, that Neil just brought up could be part of each resolution for the board.
That they have to get there.
Minutes,
Within
and
a,
then
in a timely way.
December, you know,
Oh.
2
I like
weeks
that
after
idea.
the board meeting.
Yes.
You know, that should be right along
You
the
said, oh, and then that'll be the
Yeah,
last topic.
Mike Jackson sent me a text. He was listening this morning. He would like a board member to attend Celebration Foundation board meetings because he thinks it
On a regular basis?
on a regular basis.
When is it? Yeah.
I'm happy to do that.
Oh, okay.
I'm happy to do that.
So is it all right if we make David the point person and I'll be happy to do the second?
you
In other words,
volunteer,
it's a-
I'm
there's Zoom
filling out my
meetings.
form
I'll be
here.
happy to be your second if that's all right with the board.
Okay, because we had written them off the,
So
Written
is
the
is everybody
foundation off.
happy
We
with
had
that?
writ- we had
David?
crossed
We
them
had
out.
taken them off the list, not written them off.
we had written them off, taken them off this list. Okay.
So does that mean as a board member, are we allowed to go?
Yeah.
Or is it only
No,
the
no,
person that's?
it's not, they're not open to the public. This would be David or me.
So they are not open to the
So
public?
that we're
Okay.
being invited, not as, a they're
Okay.
not open to the public.
Hold on.
They don't-
Okay. All right. I make a motion that we adjourn.
Second the emotion.
All in favor?
Aye.
Thank you all.